Lordship, in order to substitution, my lord, I file IA in contempt, Lordship. Lordship, can I take up Friday, my lord?
Why?
Substitution, my lord.
Oh,
And
come on.
Monday, my
My
lord.
I will come. Have you taken the notice or not prior to that?
Yes, my lord, because my lord,
Substitution just filed it.
my substitution, because my lord, that person has already filed affidavit, therefore formal substitution is required, my lord. In place of earlier, my lord. And affidavit in reply also we have filed.
Not filed.
My lord, Monday? Monday.
May it be the Lordship. Item number 59 and 60. Contempt petition, it has been partly complied, partly left. I have some personal difficulty in the second half. So, my lord, can it be on next Wednesday, 5th of November? To tea gardens.
Okay, we take it up after the motions.
Today.
Yes.
Okay, my lord. All right.
No, I pay for listing of a pattern matter not for today or.
What is the urgency for
The IOCL
LCL
threatened,
notes?
but the IOCL threatened the petition that his distributor will be terminated by tomorrow, my lord.
What?
The IOCL, my lord, threatened the petitioner that his license should be cancelled by tomorrow, my lord, 30th, my lord. So we have applied for a explosive license, my lord. It is still valid, my lord.
Okay.
May it please, Your Lordship. Your Lordship, I beg to mention item 8 of today's list, Your Lordship.
Yes.
Your Lordship,
No
the
steps.
the matter has become infectious, so we'd like to withdraw. This is the,
Oh, that day I remember.
yes,
Somebody else have got it.
yes.
Fighting was with some company, funny name. What was the name? Nice.
Nice.
Mr. R. Sharma appears on behalf of the petitioner and submits that the petition has become functious. Mr. I. Chaudhary, the sitting council. Assisted by so appears on behalf of the ONGC, taking into account that the petition has become infructuous. The petition stands closed, the notice the meaning stands closed.
Obliged.
Lordship, I beg to mention item 27, Your Lordship, this matter has also become infructuous, Your Lordship. It is regarding a tender of a cast, Your Lordship, for the year 23-24. So now it's 25, so the matter will become.
Your name?
The I Hussein.
Mr. I. Hussein, the council appearing on behalf of the petition. It's that the tender in question was for the period 2023-24. Each period having expired in the meantime, the petition has become infructuous. Taking into account the above, the petition stands closed. Interim orders will be extended.
May it please your lordship. Lordship, I beg to mention item number 45. We would like to withdraw this matter, your lordship. We would like to withdraw this matter, your lordship, as the cause of action is not yet, the cause of action is not existing, your lordship. Therefore, the matter related to a site visit certificate that was supposed to be issued, which was not being done by the respondent authorities. However, after passing of the previous order by this honorable court, they had done so. That is why no live cause of action survives, your lordship. T. Kashyap, your lordship.
The learned counsel appearing on behalf, petitioner submits that the petition has become infructuous, taking into account that the live cause of action no longer exists. Taking into account the above, the petition stands closed from withdrawal, or as it has become infructuous, interim orders with any extension.
Madam, may I pray for listing your lordship of a pending petition for admission column on Tuesday, lordship.
For
Lordship,
matter pertains to
lordship, the petitioner have challenged orders of passed by RERA and its appellate authority.
Lera, go there.
Lordship,
Lera is not here.
lordship,
Appeal for
lordship.
I beg to mention item number 17. This matter,
17.
this matter has become infructuous. We have received the amount.
Mr. A. Kapila, the learned counsel appearing on behalf of the petitioner submits that the petition has become infructuous, taking into account that the petitioner have already received the amount due. So taking into account the above, the petition stands closed on withdrawal. Ms. Swainso, you appear for on behalf of the animal husbandry and veterinary department.
The list item 10.
Something what has second time till.
Yes, what has happened?
Yes, Lordship, undertaking was given paying for time up to 31st of August 2025
Have you vacated?
for vacating. Lordship, we are ready to vacate any moment. But on 3 occasions, Lordship, we put tender, Lordship. But till now, we are unable to find one contractor or purchaser, Lordship, to purchase the building, Lordship.
Purchase the?
Building, I mean the RCC construction.
How will somebody purchase the building? It is
No,
made
this
in
may
its
not
own
take the
land?
script. No, Lordship, direction was for handing over vacate position. I can.
So,
We are unable to vacate the location.
so he will demolish it at your cost?
No, Lordship, another way may be there, Lordship.
Uh,
Lordship, that,
additional amount. No,
Lordship,
no, Mr. Kaushik,
that,
this is the violation of the undertaking.
yeah,
Let
no,
the person
Lordship,
come
Lordship will,
who has given the undertaking.
Lordship,
No,
otherwise we have already selected a plot of
no,
land,
I'm
Lordship.
concerned about those things. You were supposed to vacate by 31/8.
Yes.
This has come up after a long time.
No,
This cannot
only,
happen
only
like
concern,
this.
Lord, just one submission, Lordship. That building was
It
valued
is
by
a
the.
violation of an undertaking given by this.
I understand,
the-
Lordship. I understand, Lordship. I understand.
Against him.
Lordship,
You
I
have
understand.
Given that, yeah, let us initiate contempt proceedings.
Lordship, I understand that. Lordship, just one submission.
No
Lordship.
submission.
Lordship, that building has been,
Not all this for the division bench, no submissions. It is a violation of an undertaking. It will be-
Then we have to bypass the procurement rules.
Chinmoy Prakash Uttam. Initiate contempt proceedings.
Lordship will consider that building has been valued by an independent vendor. Lordship.
Concern, first of all, you construct the building on a land belonging to him. Then he has to get, if you are not in a position, give him the building.
We are ready to hand over the building, Lordship. Only the value, Lordship, value part, Lordship will consider.
Why?
It has been valued at rupees 2.9 lakhs, 2.90, Lordship. Only 2.90, Lordship.
Lakhs.
Yes.
2,90,000. The
But
government
he can
value.
purchase that building also, Lordship. No issue, Lordship, at all.
Why will he purchase?
Lordship, after all, it's a government property.
No,
Lordship.
just tell me one thing. If a person constructs a building in the government land, and you evict him, then in that case, do you provide him value of the building? I'm asking you.
Lordship.
Give an undertaking that you will provide value of the building, then very well, we'll record that and we'll ask him. Give up, you are additional advocate general, you can give that undertaking on behalf of the state.
No.
No,
Lordship,
that is the
in some
question.
cases, we paid also.
No.
So far as
Here,
that
do you
system,
give
for
it?
example,
We
is
will
here.
take it.
Yes.
Mr. Pukan would not have the problem in paying the 2.90 lakhs to you, subject to you saying that it is the stand of the state that when a person, when anybody constructs on a state land also, you are going to pay the value of the building. Give it. Then you know the consequences which is going to happen
Lordship,
in
we-
all other cases. Don't come up with.
I'm not
these things.
submitting that, Lordship. What I'm submitting, Lordship.
We are not concerned. You
Lordship-
are to hand over the
Lordship-
possession with the
Lordship-
building to him. You whatever he does, he may destroy it, whatever may be. It is never heard of in a suit. If a suit is being filed for the purpose of vacation of the for cast possession, it would also amount to demolishing or giving back the land. You don't have a right over the building. You have
Lordship-
construct
Lordship-
building on illegally over a land of the petitioner.
Lordship, direction was for handing over vacant position.
Vacant position
Lordship,
means you
on-
can't vacate the position, you have to hand over.
Lordship, under the procurement act, Lordship, we are.
We are not
bound-
concerned with
we
the
are bound to
procurement.
Follow the procedure.
Procurement Act does not come into the picture out here. Here is a case where even after 3 months after
Lord,
the
in that situation, Lordship, I am praying for just one liberty.
1 week, not more than that.
No,
Vacate,
just
and no, 1 week I give you to hand over the possession.
Yes, Lordship will give me just one liberty. That even we do not receive any response from any contractor, Lordship.
1
We
week.
can go for demolition.
You
of
go
our
for
own law.
demolition, you
That-
do
that-
whatever it may be. You have to hand over the possession to him. We are not concerned within 1 week. This is absolutely in violation of the undertaking given before.
Lordship will grant.
Can it be 10 days?
Term,
Can
10
it be
days.
10 days? Mr. 10
We'll
days.
demolish of our own lordship.
10 days.
And pay him also the dues up till that period. Till that period. Till the date of handing over, pay him the dues also.
Use of
You have to pay. You have no business to keep this land. This amount was fixed as per that amount. As on that date. When the order was passed by the district judge. Isn't it? Then you have to pay all this while all the
Lordship,
matter has been
my
pending.
friend will take just one instruction. If they are ready to pursue, we will not go for
Why will
demolition
they
even,
pursue?
Lordship. No, I am.
Are you willing to pursue?
No,
They don't want the land.
Otherwise, vacant position, we have to demolish, Lordship.
it was
That is the only issue, Lordship. Nothing else, Lordship.
specific order.
Thing called vacant possession, you have to demolish. You are to vacate the land, you have to give him the land. back.
Otherwise, Lordship, the authority will be, the MDSTC will be responsible.
For what?
What happened to
For
the
not
property.
demolishing it. For not demolishing
Not
and
for
giving it.
demolishing,
to
Lordship.
him.
What happened
Is
to
it
the-
ever heard of, Mr. Nayak, what submissions you are
Lordship,
making?
one valuation has been done, Lordship.
You have made the valuation, that is your lookout. That is, take up the action against the managing director who had authorized construction, thereby taking away the public money. Public money is being utilized in this manner, you cannot do that. Sorry.
Yes, Lordship. I'm praying for 10 days time, Lordship. We'll vacate, Lordship.
It is seen that on the respondent number 4 had filed an additional affidavit on 6th of June 2025, stating inter alia that the respondent corporation, that the petition, the respondent number 4. Wait, wait. And again. Yeah. It is seen from the materials on record
ঠিক আছে অর্ডারটা দিয়ে দিলে পেটিএম আমার কারণে হ্যান্ডেল হবে আমি ফলো করব নোৱাৰো
that the Joint Secretary to the Government of Assam Transport Department, as well as the Managing Director of the Assam Transport Department, had filed an affidavit before this court on 6th of June 2025, giving a specific undertaking at paragraph number 4 that the respondent, that the petitioner corporation shall vacate the land and hand over the possession of the land in question to the respondent on or before 31/8/2025. On the basis of the said undertaking given before this court, this court passed an order on 26/2025 recording the undertaking and directing the matter to be listed again on 3/9/2025. The matter, however, was not listed before this court. And when the matter is listed today, it is seen that the respondent, that the petitioner corporation have failed to honor the undertaking given before this court that the land would be vacant, the vacant possession of the land would be handed over on or before 31/8/2025. Mr. P. Nayak, the learned additional advocate general, submits that within 10 days, the vacant possession would be handed over to the petitioner. Who's considering the above, list this matter. 29. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. On 11th of November 2025, at the top of the list, to give an update as to whether the vacant possession of the land have been handed over to the petitioner, to the respondent herein. In addition to that, the respondent, the petitioner shall also apprise this court as to whether for the period, during this period, any amount have been quantified for payment to the respondent. Full stop. For use and occupation of the land. Full stop. Use the court.
For motion item 1.
Lordship, it is specific order was that demolition will be made by their own cost. No?
No, whatever they do, that is their lookout. They have given an undertaking.
Madam.
And otherwise, on the next date, we'll initiate contempt proceeding again.
No, value to confirm করো না, value to.
May I please the Lordship? Matters regarding non-payment of contractual amount, Lordship. This Honorable Court on 19/5/2025 passed an order to pay the contractual dues, Lordship, within a period of 3 months. That relevant portion is at page 10, Lordship. Last paragraph. Paragraph 5, Lordship. On considering the submission made by the council for the assessment board is directed to verify the amount claimed by
Where is
the
the PWD council? No PWD.
PHE, Lordship.
Huh?
PHE. And
PHE.
also, yes, and also Karbi Anglong, the executive engineer.
Oh, PHE. He is there, PHE. Give a copy to him.
Starling Associate J. Devotee Silver.
Mr. Gogoi, one thing I fail to understand. Once the court holds to follow Kamsar Ali,
Yes, sir, Lordship.
how can there be a payment? How can there be a direction for payment within a period of time? Because
Yes.
Kamsar Ali says you have to put him in the chronological list.
And there is no specific time.
There cannot be a time period.
There's even I was wondering about it. If council really comes in, the time
Because
period which
you may say that put it, make verification within 1 month or 2 months or 3 months. And put it in Kamsar Ali's thing, means put it in the chronological
chronological
list.
list.
Nothing more than that.
Yes, that's why I was thinking. Even if council really comes in,
So you get your instructions only to that effect as to whether you have made the verification as regards this amount and have put him in the chronological list.
Yeah, the issue is here the paying authority is Karbi Anglong, your lordship, Karbi Anglong.
Karbi Anglong.
It's a transfer subject.
Page
your lordship.
13, Lordship, the
Work order issued by Karbi Anglong district. Payment has to be made by them.
page 13, Lordship, the chief engineer, additional chief engineer has directed to
Karbi
verify.
Anglong, your lordship. This-
Now, if that is so,
Payment to দিছে তো সেইটোৱে দিগদাৰ হৈছে part payment to দিছে এইটো chief engineer লিখিছে executive engineer PHE
এইটো তুমি এই transfer subject হৈ গ'ল। এইটো মানে Karbi Anglong বা আহে গোটেই
হ্যাঁ,
আমাৰ বেলেগ নাই।
PHE দিছে নে
PHC Karbi transfer subject হ'ব 6
if it is Karbi Anglong, then isn't it required for the secretary of the Karbi Anglong also to be a party?
Yes.
Because they cannot pay. He has no business if it is a transfer subject. You are only issuing notice upon the additional chief engineer. Why?
Principal Secretary.
You should have made the principal secretary, you have to put notice to the principal secretary.
Because Lordship, page 13, the chief engineer has written to the executive engineer PHE
Understood?
to actually
The contractor
verify.
has written it to the executive engineer. He has done his own. He can't do anything. But if it is a transfer subject,
Yes.
the payment will be made by the Karbi Anglong Autonomous Council. And without putting them to notice about compliance, how can you have a contempt?
Let me amend the petition, Lordship. I'll make him part.
You cannot amend, you withdraw.
I'll withdraw
and
and
give you the
yes,
liberty to take
yes.
steps against them.
Lordship.
And thereafter you file
Yeah,
contempt.
yes,
Yes.
Lordship. Yes,
And that is the way out, because otherwise it's impossible, very difficult.
yes, Lord.
You have to issue a AR to all the persons out there. You have only issued the respondent. Ms. So-and-so appearing on behalf of the petitioner submits that inadvertently the petitioner had only issued notice upon the additional chief engineer, public health engineering PhD department, and not the principal secretary to the Karbi Anglong Autonomous Council, who would be otherwise, who also ought to have been issued ought to have been also served a copy of certified copy of the order. She therefore submitted that she may be granted the leave to withdraw the instant petition with the liberty to take steps against the other respondents in WPC number 3595 of 2024. And thereupon, if necessary, again approach this court. Taking into account the above submissions, this court closes the instant contempt proceedings, thereby granting liberty to the petitioner to take steps against all the respondents in WPC number 3595 of 2024. And thereupon, if so agreed, shall be at liberty to again approach this court.
All right.
Item 2.
May it please your Lordship. As directed by the last occasion, my lord, I have filed an impugning petition, including other railway. This is relating to my lord BG and my lord, which is on expiry also, they have not released. Bank is holding it. Either they should give them or us. Including
Heard Ms. Ensoikia, the Lalit Council appearing on behalf of the petitioner. Mr.
Lordship, just on behalf of
Bank.
Bank, Lordship, Canara Bank.
He is on behalf of the respondent numbers 1, 2, and 3. Gustav. This is an application file seeking leave to include the respondent numbers 4 to 8 of the instant application as respondents in the accompanying petition. Taking into account the grounds stated in the said application, it is therefore the opinion of this court that permission leave should be granted to the petitioner to include the respondent numbers 4 to 8 of the instant application as respondent numbers 4 to 8 in the accompanying application. Accordingly, the instant application stands allowed. The respondent numbers 4 to 8 of the instant application are arrayed as respondent numbers 4 to 8 in the accompanying writ petition. The counsel appearing on behalf of the petitioner is directed to take steps for, the petitioner is directed to file a fresh memo of parties before the registry of this court And on the basis thereof, the registry shall, on the basis of the present order, as well as the fresh memo parties being filed, the registry shall make necessary correction in the cost title as well as update the same in the CIS. As stands disposed. Econ River list this matter for motion after making necessary correction in the cost title.
Steps have to be taken after that, man.
Yes, you
Today
file
I can take.
within 7 days.
Within 7 days?
7 days, yeah. Memo.
Copy to the railways, my lord. Copy to the impeding railways, my lord.
Now, once you make them a party, you have to give him a copy.
Yes, my lord.
That could be.
Of
I'm
like.
not saying.
Of like.
Item 3.
May I please, your lordship? Lordship, in this case, Green Valley Rural Development Society is an NGO, has constructed, my lord, 83 numbers of IHHL. It is individual household latrine.
Non-payment of bill.
Yes, ma'am.
Okay.
So,
Which period? 23.
yes.
When were you issued the work order?
Work order was issued on, my lord, 15/12/2021. And it was completed within
Non-payment
that
of bill.
year.
You take notice for everybody. So and so. We listed on 21st of January 2026. Affidavit be filed on or before 9th of January 2026.
Lordship for respondent four,
21st, huh?
for respondent four, it's the deputy commissioner. I
It
won't
is
take it
Deputy
on.
Commissioner.
Deputy Commissioner here.
Yes.
Oh,
Obliged.
All of you file your affidavit by 21st, by 9th of January 2026.
May it
Yes,
please your
Mr.
lordship.
Nath.
My lord, the fishery was settled with me, my lord. Thereafter, I have deposited security money and also the, my lord, 10% of the revenue, my lord, of the yearly revenue. Thereafter, my lord, the position of the fishery has not handed over to me, my lord. And now they've issued an impine order to deposit full yearly revenue, my lord.
Yes. You handed over the fishery when?
It was not handed over to me till today.
And why are you asking for money?
That's what, my lord. Even the government has written to the DC.
Where's the impugn order?
My lord, page number 41. Security deposit 7,30,000 we have paid and also 10% revenue 15 lakhs we have paid, my lord. And there's a direction by the additional secretary to the DC, page number 37. To take necessary steps to hand over the position. Page 37.
Why are you making number 9 a party?
My lord, what he has done, my lord, part of the fishery, he's operating. Because in the in between two fisheries, there is no boundary, my lord, that way, my lord. So what he does, he enters that fishery. Probably there is something, my lord, that's why it is being handed over.
But you have no relief you are claiming against respondent number 8, 9. Why you are making him a party?
But for the time being,
Your case is
yes,
different.
yes.
As of now, you have not been handed over the fishery and they have demanded at some amount.
My lord,
Why you are making him
my lord,
unnecessarily-
lord, I 100%, my lord, I agree, my lord, because when I noticed, I felt the same thing in the morning, my lord. It was my fault, in fact, while drafting, my lord,
That is
that
the
way.
problem, not showing you, not.
No, I've gone through it, but my lord, that part.
Draft settled through a senior
Settle,
council.
my lord, lordship knows, nobody is perfect, my lord, that's what, my lord. And I believe your lordship, my.
Yes,
Lordship, I have to take instructions regarding this, whether it was handed over or not, and why this, they have asked for the
when will you get your instruction?
Lordship, Monday. Monday.
We state. State your impugn action. You get your instructions on Monday.
Monday.
We stay, because otherwise it would not be proper. If you have handed over, well and good, because here, what he makes allegations out here, serious allegations. So everybody, he writes a letter in December 2024, saying that, look here, you have not handed over me the fishery. The additional district commissioner also writes to the circle officer to hand over. And to the secretary writes to the DC to submit a compliance report. DC then endorses to the ADC. ADC endorses to the circle officer.
Circle officer.
Till date, they have not done anything, but the ADC puts the blame on him. This is his case.
Yes, exactly, this is what.
Chalo. Issue notice making it returnable on 3rd of November. Can get it? Monday. You are for? You are the main person.
Yes.
Huh?
They have.
The money is for whom?
This year.
Then you are the main person. You have the ADC fishery will come within your jurisdiction. Your impugn order, isn't it?
They have given the settlement, Lordship.
You have given the settlement.
Yes.
And against the settlement, that money is being taken. Okay. Issue notice making it returnable on, let's have it on 7th.
Lordship.
7th of November 2025. Miss so-and-so accepts notice on behalf of the respondent numbers 1 and 2. As regards the respondent numbers 3 to 8,
I am appearing not
Mr. S.R. Bolwa accepts notice. Extra copies of the writ petition be furnished to the learned councils during the course of the day. Insofar as the respondent number 9, the learned counsel senior counsel appearing on behalf of the petitioner submits that taking into account the cause of action, the petitioner would not like to continue the instant proceedings against the respondent number 9. However, 9 without prejudice. The learned senior counsels therefore submitted that the respondent number 9 may be struck off. Taking into account the above, the name of the respondent number 9 is struck off. The petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days. And the registry shall, on the basis of the present order as well as the fresh memo of parties, may make necessary correction in the cause title and update the same in the CIS. The case of the petitioner herein is that the petitioner's society was settled with number 1 Dorong Brahmaputra fishery at for a period of 7 years at a total amount of rupees 5,15,20,000 on the basis of an order dated 4/3/2024. The petitioner thereupon deposited the cash security deposit amounting to rupees 7,36,000. However, The possession of the fishery was not handed over in spite of various representations being submitted to the concerned respondent numbers 3 to 8. Resultantly, the petitioner had to again approach the Commissioner and Secretary to the Government of Assam Fishery Department by the representation on 18/12/2024, praying for handing over the fishery in question. Upon such application, representation being filed, the Additional Secretary to the Government of Assam Fishery Department issued a communication on 27/1/2025 to the District Commissioner Dorong, asking him to immediately take steps for handing over the fishery through the concerned circle officer as per the notified boundary without further delay to the petitioner society. Pursuant to such directions being issued in the communication dated 27/1/2025, the Deputy Commissioner in addition to the said directions, the Deputy Commissioner Dorong was also asked to submit a compliance report immediately with reason for non-handing over the site possession. Subsequent thereto, the ADC Fishery Dorong issued a communication. On the same date, subsequent thereto, the ADC Fishery Dorong issued a communication on 18/2/2025 to the circle officers of the concerned 4 revenue circles, directing them to hand over the possession of the fishery to the petitioner and to submit the compliance report. The circle officer of Mogoldo Revenue Circle thereupon on 27/6/2025 issued a letter to the circle officer of Dolgam, Pub Mogoldo and Sipazar Revenue Circle requesting them to depute the concerned LRAs along with the land records to his office on 1/8/2025. It is a specific case of the petitioner that till date, even after expiry of more than 18 months, the respondents till date, 20 months, the respondents till date have not handed over the fishery to the petitioner. On the other hand, the ADC Fishery has issued a notice on 25/9/2025, thereby asking the petitioner to submit the annual revenue for the year 2024-25 amounting to rupees 5860,000 within a period of 10 days from the date of the receipt of the letter, which the petitioner claims to have received it on 7/9/2025. 7/10.
My lord,
It should have been on, when did you receive this? On 7/10.
710, yes.
On 7/10/2025. Mr. M. Nath, the learned counsel appearing on behalf of the learned senior counsel appearing on behalf of the petitioner, submitted that on one hand, for the last 20 months, the respondent authorities have not taken steps for handing over the fishery in question to the petitioner. But on the other hand, have made the unreasonable and illegal demand upon the petitioner. He therefore submitted that the impugned demand notice is required to be stayed pending disposal of the present petition. Mr. S.R. Burwa as well as Ms. S. Sutia, the learned counsels appearing on behalf of the respondent authorities, submits they obtain instructions as to whether the possession of the fishery was handed over during the period 2024-25 and also till date. Also taking into account that the petitioner have been able to make out a case for grant of interim directions, this court is of the opinion that certain interim directions are required to be passed. Accordingly, this court therefore states the impugned communication notice dated 25/9/2025, bearing number ECF bearing number ECF NO dot 52763/748 issued by the Additional District Commissioner Fishery Dorong till the next stage.
Item 5.
7. Yes, what is this?
My lord, the non-payment of bill, my lord.
Non-payment.
Yes.
Going date today is 21st January. And you file your affidavit by 9th of January.
Some correction may be required. Respondent number 2, it should have been Assam State Cooperative Housing Federation,
Okay.
written Assam Cooperative Society, Your Lordship. Respondent-
Then you have to withdraw, file a fresh memo of parties. What do you want?
Let me withdraw it. Withdraw it and file a fresh.
Mr. So the Learned Standing Council of the Corporation Department submits. V. Rajkwana,
V. Rajkot, Your Lordship.
the Learned Standing Council of the Corporation Department submits that the name of the respondent number 2 have been incorrectly mentioned. The Learned Council appearing on behalf of the petitioner therefore submits that the petitioner may be permitted to withdraw the instant writ petition with the liberty to refile by making necessary corrections. Taking into account the above, the writ petition stands closed on withdrawal, liberty given to the petitioner to refile by making necessary corrections.
Item 6.
May it please my lord, I am appearing by VC.
What?
May it please my lord, I am appearing for the petitioner from VC. My lord, this is a simple petition. A tender was floated by the NHM department for getting ambulance services. I was one of the bidder, and along with me, 5 other bidders were considered technically qualified. This happened on 14th November 2024. Thereafter, as per the evaluation criteria of the tender, they have non-transparently invited 2 or 3 of the bidders to present their demo presentation. As I got to know this information, I made a representation on 28 March 2025.
Yes, Mr. Petala, not clear. What is it? He wants some representation to be
Lordship,
disposed
only
of.
point of consideration is that, Lordship, there was a technical presentation which has to be given by us. For 3 occasions, Lordship, we made a representation that we need to be called. The authorities never called up. They went on extending the time period. As per the bid evaluation process.
Now, what is your parent representation?
Lordship, the presentation is that it should be the time-bound manner. It should be disposed of because the bid valuation process, Lordship, it was bound by 180 days. It started in the month of 17/8/2024. Lordship may have page number 24 for a moment, Lordship. It is the NIT, page 24.
Where is the senior?
Lordship, actually, first of all, Lordship, my senior is on legs in court number 1. And secondly, a copy regarding this petition was not served on NHF.
Lordship, it was served to the government, in fact, Lordship. It was served to the government, Lordship.
Mr. Betal.
Lordship, I'll serve it within the course.
Okay. It has been submitted by so-and-so M. Bhuyana,
Lordship.
the Learned Council, to assist Mr. B. Gogoi, the Standing Council of the NHM, that no copy of the writ petition has been served. Mr. H. Petala, appearing on behalf of the petitioner, submits that the needful will be done
Within the
first
course.
of taking into account the above, list the matter on Friday.
Maybe, Lordship.
In the meantime, a copy be served during the course.
Obliged, Lordship.
Please my lord.
7.
It's a non-payment of contractors bill.
What is this?
Work order is at page 23. It's an admitted amount, Lordship. The statement of
Page?
page 23 is the work order.
When did you complete?
Within 30 days, it was supposed to be complete, and I have completed it.
Then why are you approaching this court so late?
And they
After
were
8 years, why?
they were making some payments, Lordship, and I was, they were making some payments and I was also pursuing with them.
What is this notification business?
Lordship, the
Page Annexure 7, what is this?
Annexus 7. Annexus 7 that, yes, that the office of the chairman cum managing director has been redesignated as additional chief engineer, so this notification.
And
The statement of
how much
liability
you are entitled to?
as of today, 23,91,253, page
Where,
40,
where?
page 40.
When did you request for handing over the scheme so and so?
Page 40 is the statement of liabilities.
Okay?
Page 40, 40.
Irrigation. Why you are making these people a party? What is this notification in Annexure 7?
Annexus
Reorganization.
reorganized. He has been redesignated, therefore,
Hello. We are non-payment. Going date, 21st January. You file your affidavit by 9.
much of.
Supplementary item 62.
Page 40 কাছে তার কথা mention.
May it please your lordship.
Ah, yes.
There is a ASI demand, my lord. I made a representation for allowing me to deposit in 10 installments, my lord.
What?
There was a ASI demand, my lord. Area ESI payment, my lord.
Ah,
I made a representation before authorities, my lord, paying them for allowing me to deposit in 10 installments, my lord. That has not been considered, my lord.
how much amount?
Not 3 lakh and what, my lord.
What do you do?
No, initially, I took the registration for doing the business, my lord.
Huh?
But I took this registration for participation in some tender process. But during the COVID-19 pandemic, I suffered huge loss.
Where
my
about
lord.
COVID-19? No, COVID-19 has long gone.
Thereafter, my lord,
I
my
have forgotten even what
Yes,
was there. Got himself raised away for the purpose of participating in the government and however did someone did not see to the tender process. Then mother developed some period when we have put that.
in the mean,
So how can I help you?
I have submitted an application before them, my
So,
lord, requesting them to allow me.
Absolutely, you show me, you have a right. Do you have a right? Or is it, this court should be on, yeah, what you call? Mercy.
Is a sort of
Is
mercy.
it mercy or right?
Sort of mercy petition.
No,
my lord.
right. And mercy, I left it there. It's outside the court.
Section 45F, my lord, of the section 45F of the ESI Act, my lord, it empowers the authorized officer, my lord, to stay the recovery and grant some time. It is power is there, but the application was
Grant
made.
some time, they may grant some time, nothing more than that. But you cannot have installments. Mr. M. Smith, be a bit reasonable. I don't want to pass any orders, but be reasonable, give them.
Instruction.
Yes,
Actually,
submitted a
representation was not-
representation, consider it.
Well, actually, the representation was not supported by relevant documents. That's why the petitioner may approach the recovery officer along with the relevant documents. The representation may considered based on the merits of the case. The recovery officer pass.
That is the.
If it's liable.
But you don't, I can't pass that. I will say that the representation he has submitted was not with relevant documents. And I will further say that if you, as per what you say, that if he submits the relevant documents, the authorities are not adverse to considering the representation. Not adverse, considering his representation. And on that basis, I'd say that, okay, if you say that the documents he has not, considering the representation, they will consider.
Malad, if this entitled malad under response, then it was as part of.
I don't want to pass an order thereby directing consideration of representations. But I'm doing so because you say that he has not submitted the necessary documents.
But then the representation will be considered, malad.
That is what I'll ask.
But that will-
Otherwise, I'm not direct.
That will be the. A time frame will
Because
be.
this type of orders, if I'm passing, this will open floodgates. I don't want to say it. And giving installment is absolutely within your prerogative.
That is the recovery of, if they can.
In the meantime, my lord, my bank has also been attached, my lord.
What?
Bank account has also been freezed, my lord.
Very good. That means you have money. Pay.
But they have not recovered, nothing was there. my
If
lord.
your bank account is freezed, then if you don't have money, no problem.
But my lord,
And if you have money, then you pay.
But-
Either of it.
I will not be,
Isn't it,
I will
Mrs.
not
Smith?
be allowed to any operate in business.
No, you can't be allowed. Means you have money,
No, no,
but you are not going to pay.
no, no.
That cannot happen.
No, that is not, my lord. I'm willing to pay, my lord, but
You give you go there,
my lord,
be more considerate to them, they may consider.
my lord.
Heard Mr. R.S. Mishra, the learned counsel appearing on behalf of the petitioner, Mr. M. Smith, the learned counsel who appeared on behalf of
2 and
the
3, ma'am.
respondent numbers
2 and 3.
2 and 3.
I'm appearing on this. Before lordship.
4. Ms. So-and-so appears on behalf of the respondent number 4. No union counsel. Some union counsel may get a disposal. None appears on behalf of the respondent number 1 when the matter is called. The instant petition was taking into account the order which this court proposes to pass, comma. So, it is the opinion of this court that the instant order, that the order can be passed in absence of the respondent number 1. The case of the petitioner hearing is that the respondent number 3, na?
3, my lord.
Respondent number 3, Mr. You appear for respondent number 4, 5.
Yes, sir.
Mukesh Sharma for respondent number 5. The case of the petitioner hearing is that the respondent number 3 had issued a notice dated
24 to 25, my lord.
24 to 2025, directing the petitioner to pay an amount of rupees 3,20,497 as the dues which the petitioner, as the contribution which the petitioner is liable to pay. The petitioner herein have not assailed the said notice. But the case of the petitioner is on the ground that he had submitted a representation before the respondent number 2.
No, 3.
Respondent number 2, 3, is the respondent number 3. Respondent number 3. On 8/9/2025, explaining the grounds why the petitioner was not in a position to make the payment and further seeking some time and further seeking leave to pay the said amount in 10 installments. The representation having not been considered, the petitioner has therefore approached this court. It is also the case of the petitioner that on account of non-payment, 2 of the bank accounts of the petitioner have been freezed. Mr. M. Smith, appearing on behalf of the respondent number 2 and 3, submits that the respondents are not adverse to considering the representation subject to the petitioner place submitting the necessary documents. Considering the said submission made by Mr. M. Smith appearing on behalf of the respondent number 2 and 3, this court, without entering into the legality or validity of the claim of the petitioner, directs the respondent number 3 to consider the representation, not adverse to considering the subject to submission of necessary documents. So Mr. R.S. Mishra, the learned counsel, submits, appearing on behalf of the petitioner, submits that the petitioner would submit the necessary documents within 10 days. So taking into account the above, it is observed that if the petitioner submits the necessary documents, the respondent number 3 shall duly consider the representation in accordance with law.
Much obliged. Upgraded order item 59.
Oh, yes, contempt.
This, yes, my
Who is
lord.
there for the other side? Dutas, you know?
Dutas, 5960. is the order. And item number 50, in both the cases, they have complied partly. And here, page 10 is the order, my lord.
Wait,
They paid very lesser amount.
your opposite counsel has become a judge in this
Yes,
matter.
Kolita, yes.
Ah.
But his junior should have appeared, my lord.
The
Another
junior
Kolita,
may not have been appointed. Now what is the order?
Order is at page 10. First one.
On hearing that this court is of the view that petitioner shall file a representation before respondent number 1 with regard to the claim of value.
I see.
So you have submitted the representation.
Yes, my lord.
Where is your representation?
The representation after the order, my lord, that is there, my lord.
You have not placed before this court. Now, did you submit a representation after the order?
Yes, my lord.
Where is that?
Otherwise, I have annexed it, my lord.
No.
Little bit difficult.
Where?
Uh,
We are taking up 638. Where is that representation? When did you submit?
Your lordship may first kindly taken up the second one, my lord.
First one, no
First
case.
one.
Do we drop it?
No, I'll not drop it. There is the grievances left, my lord.
Let's drop it. When did you say? that
Grievances left in the first one because they have
getting the
paid a very lesser amount. my lord. And the second one,
We submitted the copy of the order along with a representation on 8/11 before. Representation is what? I like to draw here the the honorable court after perusal of the reputation pass an order directing here to file a representation. Madam Saikia,
Yes,
this is
yes.
annexure 2 cannot be said to be a representation. How can this be? Representation means like a petition.
representation.
What have you mentioned? See,
Yes. I'm reading it.
page 14. Can you say this to be a
Yes,
representation?
my lord, to the, this is the one annexure to page 14. I would like to draw your kind attention that I have again approached the honorable court on so and so, which has not been released till earlier, my lord, in the main case, my lord, the WPC, what happened? They have calculated wrongly. It should have been 30% of the total recommended amount.
Understand everything.
Yes, my lord.
This is
But they have paid,
representation. Now you just tell me whether this is a representation.
the honorable court, after perusal of the repetition, passed an order so and so directing the petitioner. That has been enclosed, my lord, copy of the repetition. Along with the order, my lord, it has been enclosed. The repetition is like.
You have not given any representation. You have enclosed, what is enclosed is a copy of the repetition.
Repetition on the order, my lord. Because the order has been given in detail.
The direction is that you are to submit a representation. Where have you submitted a representation? Accordingly, liberty is granted to the petitioner to file a representation. Where is the representation?
Representation is there. It is the short one, my lord, and long one is there.
Where?
But
No, because in that annexure 2, you have enclosed the writ petition,
yes,
not the
and the
representation.
order,
You should have submitted a representation.
detailed representation.
We cannot get this thing complied with.
So they have partly complied, partly they have not complied regarding the amount.
You are lucky that they have complied something without a representation even. You have got some money.
Got some money.
No.
1/3 money you have
You
got.
said, go before the civil court.
Filing the representation requesting release of balance of 19 lakhs so and so and complies with the
Okay,
details
so
so and
this
so.
goes for.
Complies of order assets so and so. This is the representation, my lord. And
That cannot be a representation. And what is the other one?
other one, my lord, here, my lord, almost they have paid lesser of 26,000 less of the recommended amount.
And they say, however, Mr. Koiper submitted the impression not leviable and in case the issue regarding entitlement being.
Here they have almost paid only 26,000 less.
Okay, here against this, some money has been given or not in respect to the second one?
Paid only, my lord, from the recommended amount, they have paid 26,000 less.
Against that you have come.
No, not, my lord, after filing the contempt, in month of September, they have paid.
So then nothing remains.
26,000 anyway, my lord, they
You
have
go
paid
to the
less.
Civil court. Nothing remains. This and the other one has to be closed.
Other one, my lord, should not be closed because they have paid only 1/3 of the amount.
Understood, but you have not submitted the representation, madam.
File a fresh representation.
And then come. You cannot.
We'll file another representation. Already they have given.
If you
That's the lesser
submit the
amount.
representation.
Yes, ma'am.
Means a fresh cause of action. And after that, they may reply or may not reply. The moment they don't reply,
Already they have filed.
no, if they don't reply,
Yes,
then you come again,
again contempt, my lord.
contempt. And if they reply, dissatisfied, civil court.
Otherwise,
Whenever
my-
you feel
Can you keep it pending? And
No,
we'll file a fresh representation. You have paid the lesser amount.
Matters only happen when I get very
Lesser
tired.
amount they paid.
No, when I
Neither way they have not, my lord, they are
No,
not
madam,
fully compliant.
the keeping pending matters only happen when I really get tired at 4:45.
Second one,
Then I
first
say,
one may
okay,
close.
let it be listed on.
Second one, your lordship may close. First one, at least larger amount is due. On what?
I cannot, I give,
They can-
therefore, no. First one, I give you the liberty to submit a representation.
Yes, again.
And then thereupon, the representation which is there is not in a proper format, so I give you the liberty to submit and directing the respondents to duly comply as per the directions. I think that is a better option.
Yes,
So that is, and if you are agreed, then again contempt, you come.
yes.
And
We'll
in
take up-
second one, we close it.
Second one, yes, but only 26,000 less. Several lakhs, I think they have
Yeah.
paid. 11 lakhs something.
Second one, contempt 64684/2020.
The Dulan.
This is an application filed alleging willful and deliberate violation to the order dated 6/9/2024, passed by this court in WPC number 6036/2023. It is seen from a perusal of the said order passed by the learned coordinate bench that there was a direction upon the department for reconsideration and release of the entitlement of the petitioner by taking into account the stand of the department as reflected in paragraph 10 of the affidavit in opposition. Mrs. N. Soikia, the learned counsel appearing on behalf of the petitioner, submits that during the pendency of the instant contempt proceedings, the petitioner's dues, the entire dues except rupees 26,000
Yes,
have been duly paid to the petitioner.
the month of September 25. Month of September 25.
During the pendants. So she therefore submits that as the amount have been already paid, bearing rupees 26,000, the order dated 6/9/2024 have been duly complied with. Considering the above, this court therefore drops the contempt proceedings. Second one, economic, 638/2024. The present contempt application has been filed, heard Ms. N. Soikia, the learned counsel appearing on behalf of the petitioner. The present contempt application has been filed alleging willful and deliberate violation to the order dated 18/10/2023, passed in WPC number 6216/2023, whereby there was a direction upon whereby liberty was given to the petitioner to file a representation to the respondent number 1 and 2 in the writ petition with the grievance in respect to the amount of rupees 19,31,100, and it was further ordered that if the petitioner submits the representation along with a copy of the order within a period of 2 weeks from today, the respondent number 1 and 2 in the writ petition were directed to examine the same and make a reply to the petitioner's representation in writing within a period of 1 month from the date of receipt of the representation. The learned counsel appearing on behalf of the petitioner submitted that in pursuance thereto, on 8/11/2023, the petitioner inadvertently did not submit the representation, a detailed representation, did not submit a detailed representation, which ought to have been done. She therefore submits that taking into account that this court is also exercising powers under Article 215 of the Constitution, the petitioner be granted the leave to submit a fresh detailed representation upon the respondent number 1 and 2 in WPC number 6216/2023. As regards the grievance for non-payment of the amount of rupees so and so, 19,31,000. And the correspondent numbers 1 and 2.
4 lakhs.
The respondent numbers 1 and 2 in WPC number 6216/2023 can thereupon act in terms with the order dated 18/10/2023, passed in WPC number 6216/2023. taking into account the above submission, this court therefore closes the instant contempt proceeding, drops the instant contempt proceedings, thereby granting the liberty to the petitioner to submit a fresh detailed representation upon the respondent number 1 and 2 of WPC number 6216/2023. And if such representation is submitted within a period of 10 days from today, the respondent numbers 1 and 2 of WPC number 6216/2023 shall comply in terms with paragraph number 5 of the order dated 18/10/2023. This court further directs that along with the fresh representation, the petitioner shall enclose a copy of the present order as well as the order dated 18/10/2023 passed in 6216/2023.
Obliged.
Item 9, order for implement.
To
implement petition, my lord. As respondent number
You
7,
want
my,
to implead whom?
my lord, I am the second highest valid bidder, my lord. And he has the highest bidder, but thereafter magistrate going to inquire about the certificate submitted by fake certificate. And inquiry report also submitted before your lordship decide. So I know
The
allow,
case filed by what?
I filed by for implement, my
Or
lord.
impleading Sri Sanjeev Das.
My lord.
You are the second highest bidder.
Second highest,
So you want to be impleaded.
my lord, my lord.
My lord, here, my lord, I have filed a writ petition, my lord, only a limited period that settlement has been given, if this may be directed to settle the bill in question, my lord, with the valid highest bidder. I am not saying that it has been given to me or etc. So on the same line, my lord, the benefit will also get by him, my lord.
First, I may be
So you
allowed
will also
to.
dispose of entire matter, my lord.
Ah,
Simanta Das.
Mr. Roman, kindly come this way. We dispose it of. You
Yes.
come this way. You want your name to be put, we'll put it, don't worry. Yes, get us the instructions. Huh?
Seven certificate is.
Whose?
Writ petition.
Ah, okay. No, you take a decision.
Yes, sir.
If it is fake,
Yes.
you take a decision. Why should I say anything?
That may be considered.
You consider, we allow this petition out here. Then you consider in accordance with law.
Yes.
We will record that the certificate is fake and which will be duly taken note of while considering for settlement.
Yes.
That may not be recorded as my submission. My lord.
Oh, definitely. It will be put in bold letters.
Because they have received the instruction, my lord, that's.
Don't worry.
Technically, they have, AFDC has verified all the tenders and found all the 8 tenders are valid, genuine, my lord, as per record, my lord. Thereafter, they have opened the, my lord, financial bid. In financial, after financial bid, my lord, I am the valid highest bidder, my lord. Now, my lord, an complaint raised by on third party who did not participate in the tender process. And based on report, my lord, an inquiry is going on. That is another aspect, my lord. That will be decided by the AFDC later on. But now, my lord, your lords may dispose of it directly. To make it to valid highest bidder, that is not my lord. If this not yet, my lord, decided that whether the technical bid which were found valid is correct or not. They have already been decided that my bid is also correct.
No. Here, Mr. Raman, the
My lord.
problem is this court cannot pass a direction for the purpose of directing them to settle with the highest bidder.
Valid highest bidder.
Valid or invalid,
yes, my lord.
right? This court has no business to pass that
My
order.
lord.
This court may very well say at best that they shall consider and bring it to the conclusion in accordance with.
Yes.
And her submission, I will record it. That they say that your certificate is fake or whatever may be. But I'll say that I am not going to touch on that.
Yeah, my lord.
Leaving, and if any such decision, you are at liberty to approach this court.
Yes, my lord.
Yes.
Yes, my lord.
By taking into consideration the inquiry report, my lord.
Whatever may be, you see, inquiry report is done behind his back.
No, he is EAP.
Okay, but he has a right to challenge that also.
My lord.
And don't you have a right to challenge?
Yes, my lord.
Yeah.
As yet, they have not informed us. As yet, the AFDC has not also
Why
decided,
should
my
I
lord.
close everything? During this time when there is a dearth of writ petitions, when I'm sitting out there in bench 4, why should I stop the councils again coming before this court and filing so many writ petitions?
So when they let them file affidavit.
Why is it affidavit is required? He is not asking anything. He is not asking that he should be given. He said that the valid highest bidder should be given.
Yes.
I said that I am not going to pass that on.
Oh, have to be taken into consideration.
I will say that it will be given to the person as per their wish.
Yes.
But they are to bring to a conclusion the settlement procedure.
Yes.
But
Because this fishery cannot be run by themselves. It has to be run by only by some bidding process.
Yes.
So you have to bring to a conclusion because the delay is in fact affecting your money.
yes, and government also.
Yes.
suffering. Yes,
Sure.
suffering.
So let us first include him
Man.
so that he is also happy. Art Mr. N. Bora, the learned counsel appearing on behalf of the petitioner. Mr. B. Rahman, the learned appearing on behalf of the applicant. Mr. B. Rahman, the learned counsel who appears on behalf of the petitioner. SCAFDC. Mr. So-and-so who appears on behalf of the AFDC. And Ms. Udas, the learned additional senior government advocate appearing on behalf of the district administration. This is an application filed by the applicant who is a bidder to the bidder in respect to
Galasinga Min Mohan.
bidder in respect to Gela Singha Bill.
Min Mohan.
Min Mohan,
Right.
which is Min Mohan, and is interested in the subject matter of the accompanying writ petition, which relates to appropriate direction, wherein appropriate directions have been sought by the petitioner for settlement of the said Min Mohan. Taking into account the above, the applicant herein is included as the respondent number 7 to the accompanying writ petition. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 3 days, and on the basis thereof, the registry shall make necessary correction in the false title and update the same in the CIS. Main writ petition. Heard Mr. B. Rahman, the learned counsel appearing on behalf of the petitioner. Ms. Udas, the learned additional senior government advocate appearing on behalf of the district administration of, which one?
5 and 6.
District administration, which one? Golaghat. Mr. So-and-so who appears on behalf of the AFDC. And Mr. N. Bora who appears for the newly completed respondent number 7. So, the issue involved in the instant writ petition being the petitioner herein has approached this court being aggrieved by the delay in completion of the tender process.
Settlement process.
Of the settlement process by the respondent number 2 and 3 in respect to the Galasinga Min Mohan, and therefore sought for appropriate direction for conclusion for culmination of the said settlement process by awarding the contract to the valid highest bidder. Mr. N. Bora submits that he is the second highest bidder. But the bid of the petitioner could not be taken into consideration, but the petitioner has no claim in respect to the said settlement, taking into account the document which have been submitted by the petitioner being what document, which is false?
Board my lord,
I am objecting, my lord.
fisherman certificate.
Huh?
As a fisherman, he is not a fisherman certificate.
Fisherman certificate.
Fisherman certificate.
In as much as the fisherman certificate so submitted by the petitioner was a false document. Miss Mrs. Udas, the learned additional senior government advocate further submits that an inquiry was also conducted. And in pursuance to the inquiry, it was found that the fisherman certificate submitted by the petitioner is not a genuine one.
Yes, ma'am.
Don't use it. But one has already said fake. So let me put it's not genuine.
My lord, it is objecting, my.
This court, Mr. B. Roman, however, strenuously objects that the certificate of the petitioner is fake.
Yes.
This court have duly heard the learned counsels appearing on behalf of the parties and have also taken into account as to why the petitioner has approached this court. The grievance of the petitioner herein is delay in conclusion of the settlement proceedings. This court further takes note of that delay in conclusion of the settlement proceedings affects the revenue which the respondent authorities otherwise would be earning. Consequently, this court therefore accordingly, taking into account the limited prayer made in the writ petition, this court, without commenting on the genuine legality or validity of the certificate of the petitioner, directs the respondent authorities to conclude the settlement proceedings in respect of Gela Singh Min Mohan in accordance with law within the time frame.
Interim order maybe.
Within the time frame.
Yes.
Within the time frame of Miss So and so, the learned counsel appearing on behalf of the respondent submits that the same would be done within 15 days. Interim orders, if any, stands vacant.
One inquiry report date maybe put my lord.
Absolutely no. I said I'm not going to look at it.
I'm sorry. Apart from like that.
Let him come again. We always love to hear Mr. B. Rahman.
Which has been
whenever
by the district fishery officer genuine, my lord.
So like see the fight with Mr. Ken Bora.
Item 11.
Lordship, in this matter, Senior Counsel Ms. Bivia will be appearing, Lordship. So in some time.
Lordship,
For PTC.
matter pertains to grant of mining contract for collection of sand, gravel, etc. on tender sale basis for under provisions of Assam Minor Mineral Concessions Rules 2013. And as per sale notice, entire selection process has been initiated in terms of provisions of Rule 33(1) of Assam Minor Minerals Concession Rules 2013.
Yes,
Uh,
thank you.
Will bring up stand by way of an affidavit in 1 week's time.
What?
We'll file an affidavit, Lordship, in this regard.
they are yet to file their affidavit, Lordship.
Because Lordship, the instruction I have is of the year 2021. So I will obtain updated instructions and file an affidavit in 1 week's time.
So,
Settlement given by the PDC or
I'm asking you for the law.
that issue is that
Leave your place. You don't know anything. Give it to him. Mr. Gugoi, here the contention is this. That after the minor minerals having been already minor mineral rules 2013 coming in force. And more particularly the amendment made in the year 2018. Can the AF take steps which is contrary to Rule 32? At the over, then that is it. What is there to file affidavits? You have not cared to file affidavit for the last 5 years. Now you are taking up and this is unnecessarily going on. You want to settle it as per law. You can't settle it in this manner.
yes, Lordship.
We are not stopping you from settling it. That's it. If you don't settle it, it is a loss to you. But by allowing this continuation of the interim order, it is not in the interest of the BTC.
True.
It is being stayed. This is not in accordance with law, the manner in which the tender has been floated. Isn't it?
Lordship may arrange this instruction
What is the instruction?
of year 2021.
But this is of 2021. Now I think BTC has the can go for e-auction. Doesn't the BTC have the e-auction facility? Because I remember while taking up that matter pertaining to where is Mr. Boragon? There was one matter I took up very seriously in a case where there was a they did not invite it properly. In fact, there were two newspapers. You remember?
Yes.
There were two newspapers. One was a newspaper which Mr. D. Das had, where there was no advertisement. And one was a newspaper
sir.
where the BTC authorities and everybody had, where Mr. J. Ahmed was appearing, which had the advertisement. And when I took up the matter and asked them to get the ear from the director of printing and publishing, they provided the newspaper which did not have the advertisement. Then the DFO, this particular DFO, this Parbat Rizora Forest Division, he came up and said that, look here, I'm very sorry. I didn't know. I, in fact, instructed him to do it and I was informed that it had been done. But anyways, I dropped that issue thereafter. But in the meantime, there was a fresh e-tender. Now e-tender happened. Were you there in that case?
In that case, I wasn't, but I'm aware of that case, Your Lordship. If the e-tender has been introduced in BTC area, e-tender process can go on.
So if this is the instructions, we'll have it after some time. Get the instruction whether there is a e-tender. I think I remember now they have a e-tender. At that point of time, they didn't have the e-tender. We'll take it up. We'll finish it on. Matter go like this.
Item 12.
Yes, what is this? No representation earlier.
May I proceed with it? I am behalf of my senior, Mr. I. Rafiq. My lord, I've been instructed that it is practice.
Infractions.
Yes, in practice.
Mr. Your name?
Chonben Zetyantan.
Huh?
Chonben Zetyantan.
So and so appears on behalf of the petitioner. Mr. S.R. Burwa, the learned counsel submits that the instant petition has been rendered infructuous in view of the fact that the petitioner have been duly paid the dues. No, then, anyway, heard Mr. So and so appearing on behalf of the petitioner. Mr. S.R. Burwa appearing on behalf of the respondent submits that the entire case of the petitioner does not have legs to stand, taking into account that the vehicle of the petitioner being AS01 GC 7394 was not requisitioned or hired by the office of the superintendent of police.
Lordship, that affidavit has been filed by respondent number 7. They have said the vehicle was not requisitioned by the SP Kachar, but it was hired by the authority of Guwahati Authority Commissioner.
And then?
Then we have a instruction of 2023. Then we have sent a proposal for the for sanctioning. Perhaps they have got their payment.
You've got the payment.
That's why they have said.
No, Mr. Counsel, if you don't know anything, don't say. Ask your senior to come. This is not how you appear. Where is he? So this amount you are admitting?
Yes, yes. It was already sent to the sanctioning authority. Perhaps they have got the relief because it was of 2023 also. What is Lordship on next day? I will obtain the instruction whether it has been paid or not next week also.
Mr. So-and-so, who appears on behalf of the petitioner, submits that the writ petition has become infructuous, but is not aware, but cannot further say as to why the writ petition has become infructuous. On the other hand, Mr. S.R. Burwa, appearing on behalf of the respondents, submits that as per his instruction, the vehicle of the petitioner was taken on hire for the period from 23/7/2021 to 19/9/2022, that is 424 days. And against that, as per his instructions, the details as regards payment, the aspect pertaining to the payment of rupees 7,54,720 have been sent to the sanctioning authority. He therefore submits that some time may be granted so that he can obtain instructions as to whether the petitioner have been duly paid his dues. The instructions of provided before this court is kept on record and marked with the letter X. Lists this matter on 3rd of November 2025 for instructions.
13.
In terms of the order, your lordship, an IA has been filed for implement,
I asked him.
but it is not, it has not come, your lordship.
Mr. M.H. Loskot, the learned counsel submits that an interlocutory application has been filed for implement, which has however been not listed. List the incident matter along with the said application after 3 weeks.
Oblige, lordship.
The Sri Goswami appears on behalf of the railways or BSNL.
Oblige.
May I please your lordship, the matter here pertains to non-payment of contractual bill, lordship. The work order is at page 14.
Non-payment.
Lordship. The work order is at page 14 and the admitted liability.
Central government, no. Okay, verify and pay. See work orders, everything and all. Which year work order?
Lordship, 2018 work order. Page 14, lordship.
Where you have just submitted the final bill? Have they acknowledged anything that
No.
you have submitted the final bill?
Lordship, for that, that is duly attested by them, lordship. They have signed the bill, lordship. It has, page 17, the bill amount is reflected. That is attested by the Assistant Executive Engineer, Udalguri Water Resource Subdivision, Udalguri.
To verify, go to cite a ground that there is no work order, everything will have all documents submitted and all the 6 months. Whoever it is, and it will be submitted to the certified copy to the principal secretary BTC. Give your names.
15.
Much obliged, lordship.
What is this I business?
My lord, for implement of the revenue department, my lord.
Not done.
My lord, actually, as per their instruction, that payment has already been sanctioned, but the amount was not disbursed because, and then.
My lord, as per our instruction, my lord, paper 7/6/24, including one letter dated February 2023, where my lord, as district commissioner has already mentioned that written to the my lord, principal secretary government Assam Revenue and DM department that here for your request to kindly sanction an amount of rupees 19,67,504 only for payment of compensation to the petitioner. As the Honorable Guwahati High Court has desired instruction from the commissioner. So, my lord, written to the now it is my lord, revenue and disaster management, my lord, who will release the fund now.
For what compensation?
Workman compensation, ma'am. Workman compensation. Now it is employees compensation. Workman, under a Workman Compensation Act, as it is now, my lord, read as Employees Compensation Act. They were working as laborers and they, 5 of them were working as laborers under the district administration. And there was some disaster and then 2 of them expired and 3 of
So
them-
there is an award passed by the workmen compensation
and then.
and they have not complied.
They have not complied.
Why you are not taking action against that workmen compensation
My
if
lord,
they have
the
not complied?
Bakijai also
They should be,
proceeding initiated, my lord, and
Yes, let us see the provision by which, how it can be done. If they are not making the payment,
my lord, Bakijai proceedings have been
as per
initiated,
the workmen compensation,
my lord.
if there is a how,
Yes.
effect of failure to raise the appeals.
Recover.
Appeal filed.
Section
recover.
31.
The commissioner may recover an area of land revenue any amount payable by any person under this act, whether under an agreement for payment of compensation or otherwise, and the commissioner shall be deemed to be a public officer.
Yes, my lord.
So they can take this money from as area of land, Bakijai proceeding
Yes,
against the commissioner and secretary,
No,
revenue department,
no.
as well as the deputy commissioner,
Certificate has already been issued by Bakijai authorities also,
against them.
my lord.
But then also they have not paid. Okay.
Now,
So certificate, then we'll ask why it has not been done. And again, I think we should have that person concerned.
My lord.
Because then you can hear the person concerned, huh?
now revenue department is to release the fund, my lord. Already, my lord.
Mr. I don't understand. When there is a direction passed, where is the award?
My lord, award is annexure 8, my lord. Page 99. Hmm.
Okay, it is the deputy commissioner.
Yes, my lord.
Hello, then it is the deputy commissioner. We are not concerned. No, we don't want the revenue department out there. No, nothing.
Our part, my lord.
Nothing. You are absolutely in violation of the provisions of the Employees Compensation Act. If you are not making the payment, what is the amount due?
My lord, there
19 lakhs.
19 lakhs in all.
Chalo, we ask you to provide the bank account, head of account of the DC, and we'll seize it.
That case, my lord, may I?
We'll seize the bank account, nothing doing. Madam, nothing. I'm not concerned with what the revenue and all these things. These are poor laborers. You are not making the payment. They have had to go to before the employees compensation and before the workmen compensation. The commissioner had the power to had passed the order. Then also you have not filed an appeal. And if these authorities violate the law in this manner, then nothing can happen.
Now, my lord, payment is to be made by the revenue department, my lord, because already lordship has been pleased.
No,
to
no,
say
I'm not
payment
concerned
is
with
made,
that.
my lord.
How you get the money? We are concerned
That's why
that
the
you
revenue
know
department
you
is
are
fighting
the
with
deputy
lordship
commissioner
now.
was a party in that WC matter.
No.
Deputy commissioner was a party. Did the deputy commissioner raise the plea that no, I have nothing to do. It is the revenue and business.
Yes, it's part, my lord.
No. This is not a question of contempt. This is not a question of EI. If you don't pay and there is a interest, madam, isn't there?
Yes, 12% interest.
12%. With 12% interest, you have to pay this amount.
It is, my lord, violation of the honorable court. my lord.
Provide. No, there is not a question of violation. It is a question of non-compliance.
Case of
And we will ask this compliance. Provide the head of account.
It's a case of.
Close the
violation, my lord.
which is the deputy commissioner concerned. Deputy Commissioner Dhubri, provide the head of account of the Deputy Commissioner Dhubri. We seize it. We'll freeze that till you don't pay the amount.
My lord,
Nothing doing.
my lord, he has.
7 days, make the payment. 7 days you make the payment.
Lordship may please to.
7 days you have to make the payment. You cannot. Madam, you know, we don't require the revenue department here.
My-
We don't require this revenue department. This is a simple case where the deputy commissioner has to pay.
My lord, may be passed.
Interest is 6%.
Otherwise, the deputy commissioner ought to have been.
My lord.
We are not concerned with the finance department or anybody. We are concerned you have to pay otherwise. And if you don't pay, you also provide the head of account. We seize it.
My lord, my lord.
So that nobody gets a salary, even the deputy commissioner does not get a salary.
Won't stand.
No, 10 days.
My-
10 days you pay on 11th. Another matter is there no, on 11th. 11th of November, we take it up for update.
Well, interest is 6%, not 12. 6% interest.
Along with interest, 6%. All payment has to be made.
My-
Therefore, heard Ms. P. Chakraborty, the learned counsel appearing on behalf of the petitioner. The present petition and Ms. Udas, the learned additional senior government advisor. The present petition relates to has been filed by the petitioners being aggrieved by the actions on the inaction on the part of the respondent authorities, more particularly the district commissioner, Dhubri, in not honoring, in not making payment of the compensation to which the petitioners are entitled to in terms with the awards passed by the commissioner, Workmen Compensation Dhubri, in WC cases number
39,
numbers
39, 40, 41,
WC numbers where
39. Lordship finds it at page number
39.
40,
I will see number 39/2003, 40/2003, 41/2003, 42/2003, and 43/2003.
that's right.
And further, in accordance with the certificate issued by the certificate officer Dhubri, dated 5/11/2014. Pusto. Then when the matter is being taken up, Mrs. Yudas, the learned counsel appearing on behalf of the petitioner, a respondent, Deputy Commissioner, District Commissioner Dhubri, submitted that for release of the said fund, a request has been made to the Principal Secretary to the Government of Assam Revenue and Disaster Management Department on 22/2/2023 of a total amount of rupees 19,87,504. However, the said amount have not been paid. In that regard, he has placed before this court an instruction dated, she has placed before this court an instruction dated 7/6/2024, which is kept on record and marked with the letter X. This court have heard the learned counsels appearing on behalf of the parties. And the dues which the petitioners have been held to be entitled to by the Commissioner of Workmen Compensation are for the period prior to 2003. It is really a very sorry state of affairs that even after the awards being passed in the year 2014 and a certificate having been issued, award passed when?
2013, my lord.
2013, and certificate issued by the certificate officer. The district commissioner, Dhubri, have not taken any effective steps for making payment. It is also seen that the certificate officer have also not taken effective steps so that the said recovery could be made as areas of land revenue. Considering the plight of the petitioners, this court fixes this matter on 11th of November 2025. On such date, the district commissioner either on or before such date, the said amount be paid, the amount to which the petitioners herein are entitled to be paid by the district commissioner, or the head of the account of the district commissioner Dhubri be provided before this court. List according. We seize it, freeze it, then nobody gets any payment.
16.
We get the money. Don't make all this. Yes, what it is. I can't know.
Should be better actually, it's a recurring non-payment of part payment of a contractual amount. Actually, here the matter is that lordship, actually, they say that I have to implement the deputy commission lordship.
The last order of the court, your lordship, 6/1/25, you are directed to implement deputy commission.
What?
Order dated 6/1/2025, your lordship.
What are they're claiming that deputy commissioner should have met party lordship, but I haven't met party lordship.
But if payment has to be made.
How will they verify? These are matters of 2010. How will she verify, tell me? And first of all, these may be from some funds. These funds have gone. Why have we approached of a matter pertaining to 2010 in the year 2023? Tell me.
Their lordship, they delayed the matter, lordship, we approached several
No,
times. Yes.
a delay means understandable is 1 year, 2 years, 3 years. Not beyond that. This is a case you have approached this court after 13 years. How will they verify?
Now, lordship,
is gone.
recently, they given the liability recently, lordship.
Liability statement is nothing to do.
Yes, lordship, in
How do they know about
2022,
this
lordship, they
liability
have,
statement?
22, lordship, they have given the details, lordship.
These executive engineers are creating havoc.
Yes, sir.
Everywhere. What is wrong with this? Why I'm taking up on one matter of the PHE department where I'm asking the commissioner to be present. In respect to these, they are reopening issues. And this, I'm telling you, you see, this executive engineer gives this. What is the name of this executive engineer?
Name, I don't know, lordship.
Then, how can you say that? Go before the civil court on the basis of this and file it.
Lordship, this is
No.
whoever on that time, lordship, who has authorized.
You did not
During the
do
sale, lordship, he was issued the.
Mr. Counsel, you did not do anything. On why on earth did he issue this liability certificate in the year 2022 when from 2012 onwards you are completely silent? Why?
I'm not silent, lordship. I have also, lordship, explained the delay, lordship, how, lordship, it delay occurred, lordship.
How?
Lordship, we actually, lordship, we several times, lordship, approached the day, lordship, issued, lordship, that they will pay.
Issued.
Yes, lordship.
It
they-
is called that the Supreme Court said, na, some case of Kumbhakarna. You come directly within the ambit. Kumbhakarna used to sleep for 6 months, you have slept for 10 years. Yes, with this.
And also, lordship, then lordship, is similar order, lordship, in this similar.
Similar order, I have many similar orders.
No, regarding the
It is
same
this
scheme,
type
lordship,
of
regarding the same scheme, lordship, at the same time, lordship, they also, lordship, did the work, lordship, they approached the court at the same time, lordship.
You did not approach this court or anybody else within the time. I would have understood, okay, 3 years, 4 years is okay, excusable. You have approached this court in 2023 in respect to a claim of 2010. How can they do it? And this executive engineer have given this. I've given you the liberty. Go before the civil court. I am not going to pass this type of orders. Madam, there are many similar orders passed by me, dismissing. See? I can't go against my own order.
Another similar order is of their lordship there.
Other courts is other courts. Those are lucky judges, lawyers and lucky judges. I am not there. I am not going to pass this type of order. You take away the right of defense. How will they verify? Tell me. How will they verify after 12 years? This is of 2000. After 15 years, how will they verify whether you have completed the work? Where is your completion certificate? Let us see.
Certificate is there, lordship. Certificate I have no next lordship. The orders, lordship, only work order is there, lordship.
No, where is your completion certificate?
Certificate I have not.
Then show me the completion certificate. Nothing is there. How do we exercise the
Now,
the
when
2
the
to 6?
the liability lordship, they say.
There are the liability certificate. This court does not, you see, as per many judgments of the, even in Taslim Ali also, Tamsir Ali also, the certificate has to be given by the chief engineer. This type of executive engineer we don't trust. And I'm taking up another matter of the PHE strongly on this asset. How these executive engineers are giving, in how many cases they are doing.
So lordship, then lordship, in two other cases, lordship, they filed.
Division bench may
affidavit,
help you out. I'm going to dismiss your petition right away.
They have also not filed affidavit, lordship.
Not necessary. How will they file affidavit? See the plight after 15 years, can they ascertain? Where is your completion certificate?
Lordship, in another case, lordship, in my case, lordship, they admitted this everything by affidavit, lordship. So lordship, at least lordship, they may be, lordship, given chance to file affidavit, lordship.
Go as per my orders. I'm not going to pass any order. Heard Mr. S. Hawk, the learned counsel, appearing on behalf of the petitioner. Ms. R. Dekka appears on behalf of the respondents, all the respondents. Huh?
Respondent number 3 is financial.
All the respondents except respondent number 3. Mr. A. Solia appears for the respondent number 3. Yes, Mr. Solia, what is your submission?
This is a long time contract, lordship. Here, the water resource department has to first verify, lordship, as to the payment that needs to be made, lordship. And finance department has a very limited role in this, lordship, because the work has been allotted by the water resource department. Whether he has completed or not, that has to be verified by the authorities in the water.
So your finance department does not have any notification asking these people to do something, that this type of liability certificate should not be issued?
Here, that aspect, lordship.
You issue every type of notification,
Lordship.
don't you do so?
Lordship.
By finance?
Yes.
That you don't do this, you don't do this, you don't do that,
Yes.
isn't it?
Yes, lordship.
Then why we are not doing anything to that effect?
Lordship, yeah, yes.
At the end of the day, the money,
Yes.
what is the finance department for?
Mm.
They are to oversee as to whether the
Yes.
things have been properly done
Yes.
or not. And then after the release, that is why they make them a party.
Yes, lordship. That-
Unless this amount, just for example, they admit it, I pass an order also.
Lordship.
They will verify and then put the sanction to you.
Yes,
Are
lordship.
you not going to look into it?
Yes, that time, yes, with the, all
And
the.
then what happens? The moment you look into it, then you put an objection.
Yes, lordship. That-
And when you put an objection, then he comes in contempt.
Lordship, yes.
And then you have to again pay.
Yes, lordship, that is the, yes.
And they are not in a position to make a verification after 15 years.
Yes.
Huh? So and so appears for a hard, yeah. The petitioner herein is aggrieved by the non-payment of an amount of rupees 19,22,967 against various works done by the petitioner, and further sought for interest at the rate of 18%. It is the case of the petitioner that the petitioner was issued various work orders by the respondent number 5 during the period from 26/8/2010 were issued various work orders by the respondents in the water resource department on 26/8/2010, 7/8/2012, as well as 17/7/2010. The petitioner states that the petitioner had duly completed such works. However, no work completion certificate had been enclosed to the writ petition. Thereupon, the petitioner, nothing appears that the petitioner had done and slept over his rights. Till he was issued a liability certificate by the executive engineer of the water resource department on 21/12/2022 that an amount of rupees 19,22,967 is due. On the basis thereof, the petitioner submitted a representation on 30/12/2022, which was received by the respondent on 19/1/2023, and immediately thereupon filed the present writ petition on 27/3/2023. The record reveals that this court issued notice. However, the respondents have not filed the affidavit. Mrs. R.F. Dekar, the learned counsel, the learned counsel appearing on behalf of the Water Resource Department submits that it is very difficult to file the affidavit in matters of the present kind, taking into account that the works in question were awarded in the year 2010 and 12. And the petitioner has approached this court in the year 2023. the learned counsel further submitted that it is not known as to on what basis such liability certificate have also been issued by the executive engineer. That too, without there being any work completion certificate. The learned counsel further submitted that this is a case where a valuable defense of the respondent authorities have been taken away on account of the delay in approaching this court. Mr. Esolia, the learned counsel appearing on behalf of the finance department, submitted that the water resource department having issued the work orders are required to verify, and when any amount comes for sanction, then only the finance department will raise objection as regards calling for necessary documents. This court, having heard the learned counsels appearing on behalf of the petitioners as well as the respondents, is of the opinion that the petitioner, having approached this court after a passage of a decade, when the work orders have been issued, and there being no work completion certificate also enclosed, it is the opinion of this court that any directions passed for verification and then to pay would would seriously impact the decision, impact the rights of the respondent authorities. Seriously affect the rights of the respondent authority. Considering the above, this court is not inclined to exercise its jurisdiction under Article 2 to 6 of the Constitution. Be that as it may, and accordingly the writ petition stands dismissed. Be that as it may, the petitioner herein is given the liberty to approach the competent civil court if so advised, and if so permissible under law, and the period during which the instant writ petition have been pending, that is with effect from 27/3/2023 till date, be excluded while computing the period of limitation.
Timing item 11.
Yes,
Lordship.
you have the e-portal and e-auction or not?
As of now, we have received instruction yesterday, and out of the Parvachora division, my lord, only 2 are running.
I'm not concerned with
Yes.
that. Here the issue which that, where's the lady advocate?
Lordship, she will come, Lordship.
Let her come.
Lordship.
Here the issue is, you could not have gone by way of a tender in this manner. It should have been by way of an e-auction. Now I think BTC has e-auction.
Lordship, the instruction which you have received.
Your instructions are not. I'm concerned now you have e-auction.
No, yesterday we have received an instruction. Senior Standing Council had received an instruction where it has been stated, my lord, not is started, my lord, settlement of Mohans. E-auction has not been started. Lordship, we'll instruct it, your lordship, at the earliest we'll do the needful, my lord. We'll instruct the authorities to do.
No. There was a system of e-auction. It has been done. Your instruction is wrong because
Maybe it was given by CHD Forest BTC yesterday, last night at 9 p.m.
Because I remember there is another matter where the e-auction was done. Wait, let Mr. Bora come, as Bora, he was the earlier council. There was one matter which I passed an order out. Now, when
the
Rule
Forvachura
33
division, Your Lordship.
where it comes out, minor minerals. When Rule 33 which rules are we concerned? But you are public notice for inviting tender. A public notice of renewal shall be published for inviting bids or conducts of open auction for so and so in addition to publication of notice, e-auction under Rule 1 above the gist of the notice so and so. So as per 34(2). What could I say?
Oh my goodness.
So now you have only e-auction.
Yes, Your Lordship. In the Parvachura division, I have a specific instruction. In the Parvachura division,
Parvachura.
the division in question, my lord, it hasn't been started yet.
But there's no started yet. All other places it has started. In this division itself, there was another case.
Here, item number 20.
No, not here today. I've disposed of another matter. What was the matter? So there is only, you can only have e-auction, otherwise you cannot.
Yes, Your Lordship, very much correct.
So we cancel the tender process
Leave it to Your Lordship.
because that was done in violation of 34(2). Isn't that the case?
It is also possible that we have the purchasing areas available in the or which are the other one. Is the last date of.
One. Save. So 32(1) and 33 e-auction. So they have removed the competitive bidding. And if you don't have e-auction, matter over, you cannot go for. Heard Miss So and so, the learned counsel appearing on behalf of the petitioner. B. Bhuya, the learned senior counsel, who is also, you are standing counsel?
Yes, sir.
Also the standing counsel of the PTC. Appears on behalf of the respondent numbers 1, 3, 4. Ms. Yudasik, the learned additional senior government advocate, appears for the respondent number 5. And Mr. R.R. Gogoi appears on behalf of the respondent number 2. The petitioner herein is aggrieved by the issuance of the sale notice dated 29/11/2021. which is into sale notice dated 29/11/2021. On the ground that the same is not in compliance with Rule 31, Rule 32, 33, and 34 of the Assam Minor Minerals Concession Rules 2013 as amended by the Assam Minor Minerals Concession Amendment Rules 2018. Ms. So-and-so, the learned counsel appearing on behalf of the petitioner submitted that in terms with the Assam Minor Minerals Concession Amendment Rules 2018, for short, the amending rules of 2018, the words competitive bids / open auction appearing in Sub-Rule 1 of Rule 32, Sub-Rule 1 of Rule 33, and Sub-Rule 2 of Rule 34 have been substituted by the words e-auction. The learned counsel therefore submits that under such circumstances, the respondent number 4 could not have issued the sale notice on 29/11/2021. When such sale notice could have been only by way of e-auction. It is seen that the respondents, it is seen that pursuant to the filing of the instant writ petition, this court by an order dated 20/11/2021 directed the divisional forest officer, directed the respondent number 4 not to finalize the bid submitted by the bidders in terms with the sale notice dated 29/11/2021, and further permitted the petitioner to participate in the same bid process. The interim order thereupon have been extended from time to time, but the respondents, more particularly the respondent number 4 and 5, 3, 4, and 5, 3 and 4, have not filed any affidavit in opposition. This court further takes note of, so taking into account the above, today, when the matter is being taken up, Mrs. B. Bhuiya, Ms. B. Bhuiya, the learned senior counsel as well as the standing counsel. A senior counsel cannot be a standing counsel. No. Learned senior counsel appearing on behalf of the BTC submitted that as per her instructions so provided, the BTC have not evolved the e-auction mechanism. Under such circumstances, this court inquired with the learned senior counsel appearing on behalf of the BTC as to under what provisions the BTC authorities then settled the settle the rights of minor minerals within their territory? What is the answer?
Answer, Lordship, without instruction, my lord.
No instruction cannot be, this is a law. I'm asking you, what is your instruction under what authority does the PTC settle?
When the law stipulates that certain things has to be done in that manner, your lordship. It has to be
So you
done.
admit that
So
the PTC does as per the Assam minor minerals?
Lordship, but it has to be under your option, my lord, but they have
Not
not
on
done.
that. I'm asking you, does the BTC do in terms with the Assam minor minerals? Oh,
They do,
yes.
your lordship.
The Learned Senior Council submits with all fairness that the BTC authorities take steps for settling of the rights of in minor minerals in terms with the Assam Minor Minerals Concession Rules 2013. Considering the said, this court duly perused the provisions of Rule 32, 33, and 34, as was amended by the amending rules of 2018. 32, 33, 34 of the rules of 2013, as amended by the amending rules of 2018, whereby it is seen that settlement by way of competitive bids of the open auction have been substituted by e-auction with effect from 29th of October 2018. That is the date of publication of the rules, amending rules of 2018 in the official gazette. Full stop. Under such circumstances, the sale notice so issued, impugn sale notice dated so and so, dated 29 so and so, so issued 29/11/2000, so issued, cannot be sustained in law, for which the same is set aside and quashed. Accordingly, the writ petition therefore stands allowed, thereby setting aside the sale notice dated 29/11/2021. This court further observes that setting aside the sale notice dated 29/11/2021. Yes, next. The respondents in the BTC would be at liberty to put on auction, sale the sand mohols, which were the subject matter of sale notice dated 29/11/2021, in accordance with the extant law, that is section Rule 32, 33, and 34 of the rules of 2000.
Lordship, I think 23.
Huh?
I think 23 is considered forward only.
What?
23.
This is item what?
16.
11. This is item 11. Now,
23 also.
what is the, let's see what item is coming. Next item.
7.
The next item to be 18. 18? Your matter is over?
Much obliged, Lordship.
Yes, 18. Non-payment.
My lord, in this case, my lord, petitioner already got the relief, my lord.
Got the relief.
My lord.
Mr. P.C. Day, the Learned Counsel appearing on behalf of the petitioner submits that the petitioner have already been made, received that use, and as such, the petitioner, there is no live cause of action. Miss so-and-so appears on behalf of the KAC, and so-and-so appears on behalf of respondent number 1. Accordingly, the petition stands closed as it has become infructuous.
19.
Think that amount except one of 24, Lordship, will you please to pay with our affidavit manner?
Lordship,
Yeah.
we have yet to receive rupees 1,07,000. And Lordship, they, in the affidavit, they sought a bill and we have submitted the bill, Lordship.
80 lakhs you have got.
Lordship,
You want.
The four have already been paid, my lord, and remain, one B, paragraph 8, my lord,
24,000 is not there.
is not there, so if they, submit the bill.
No, we have submitted, Lordship.
So therefore, only 24,000.
Yes,
No,
that too.
Lordship,
subject to-
I,
No, Mr. Council,
Lordship,
if you have
Lordship.
anything more, then in that case, you have to file your reply. Where is your reply?
Lordship, I will file reply, Lordship.
No, matter what.
Lordship, kindly, Lordship, because,
No
Lordship,
kindness.
kindly peruse.
Kindness-
Last page.
Kindness of this court is no longer. No, Mr. Council, do you expect this court to look?
No,
into-
only one point,
Yes.
Lordship.
Guru.
Lordship, the payment we receive, Lordship.
No, I'm only concerned that you have received 80 lakhs, so and so, and they say
No.
only 24,000 is remaining.
Lordship,
You do one thing. You
26th
you
of
will
July,
again file another petition for another period.
no, Lordship,
come
only, Lordship, kindly grant me 10 days time, Lordship, we will file affidavit.
No.
Clarifying all the things, Lordship.
So issued on 31/7/23, and we paid the amount, the last, up to 80 lakhs, my lord, on 26th of July, even prior to issuance of notice. And the remaining amount of rupees 24,000, that is subject to submission of the bill.
Lordship, I have received 17 lakh, 79,000.
Let me come back at 2 to say that nothing remains except 24.
Lordship, kindly grant me 10 days time, Lordship, we will clarify.
I'm giving you 1 hour. File your reply 1 hour at 2 o'clock.
Lordship, the
Or I
person is
can give you more.
kindly, Lordship.
2 hours. We can take it up at 3.
Lordship, he is Bukakhat only, Lordship.
So Bukakhat, let him be there in Bukakhat. But the fact remains that you have not filed a reply. You see, the question is,
Lordship,
if
we
there-
have-
Mr. Council, you have to understand, if there is a dispute
Lordship.
which they have not paid, you have to go before the civil court.
No,
This
Lordship,
cannot.
I'll,
I'm not going to look into all this. And if you have received the amount prior to notice being issued by this court.
no. That is why, Lordship, we have.
Let me come back at 2 and then we'll see as to whether it's a case of
Lordship.
dismissal or with closure. Yes, item 19.
Met legal, Lordship. Lordship, we have filed our writ petition on 24th of July. Notice of motion issued on 31st of July, Lordship, and payment received, Lordship, on 9/8/2023.
What? You filed it on
24th of
24th
July. July 2023. And notice of motion issued on 31st of July 2023. And Lordship, payment received on 9/8.
Our paid 7 is, my lord.
Paragraph 7. Order of pay. Payment received for is 9/8.
You got the money on 27/6.
No, Lordship, that is the date of order, Lordship.
Date of,
Date of order, Lordship, and we received on 9/8, Lordship.
So you got the money.
No, Lordship, minus 1,07,000, Lordship.
Yeah, then what remains? Only 24,000.
That is why, Lordship.
So 24,000, you submit the necessary bills, they will consider.
We have already submitted, Lordship.
They say that you have not submitted.
No, Lordship, we have submitted, Lordship, on 27/9/2024.
Oh, then you have submitted, they will consider.
after filing the affidavit. File the
Yeah, they will consider.
Lordship, kindly peruse paragraph 5, Lordship, for a moment, of their affidavit, Lordship.
Yes.
Lordship, got it that with regard to the amendments made in paragraph 4 and 5 of the writ petition, the deponent basically stated that the petitioner firm submitted the bill of total amount rupees 80,75,025 and received 61,88,207, Lordship. That is the calculation we have made, Lordship. It comes 18,86,818, which is exactly our claim, Lordship. But paragraph 5 and paragraph 7 are self-contradictory, Lordship.
No. There is no quarrel with the fact that you have submitted the bills,
Lordship.
but the bill was not found. That is what they say.
That is in respect of rupees 24,000 lordship.
Yes.
But our claim is that we have received rupees 17,79,000 on 9/8/2023 lordship. And the rest of the amount yet to be paid lordship. Lordship, kindly paragraph 5 and para 7 are self-contradictory lordship of this. Let me, lordship, kindly allow me next week lordship will file an affidavit clarifying everything lordship. The person is a old age person lordship. I have already communicated with him lordship. Next week, any date lordship. Lordship, we have calculated out and our prayer is also for 18 lakh lordship, 88,000 lordship. Paragraph 5 is clear lordship.
The counsel appearing on behalf of the petitioner submits that the contents of the affidavit filed by the respondent number 3 are not self-contradictory and would like to file an affidavit in reply. This is the matter of the 6 weeks.
Item 20.
Lordship, the petitioner has received the amount, Lordship.
That means Ms. So-and-so appears on behalf of the petitioner. Demon.
Yes, Lordship.
Mr. N. Upadhyay appears on behalf of the irrigation department. So it has been submitted that the petitioner have already received that use. And as such, no live cause of action survives. Considering the above, the instant petition therefore stands closed. With the instructions.
Production list, item 1 for motion.
So BPCL is fighting against.
No, madam.
Field.
Is a private, no, IOCL, madam. I'm against the IOCL, madam.
You otherwise appear for BPCL.
Yes, madam.
BPCL is fighting against IOCL. Tell me.
Madam, on my appearance, madam, I have filed, madam.
He's in the shows of a private individual, man.
Otherwise, isn't this the standing council of BPCL?
Understand, madam? He is against IUCL in this matter.
Huh?
He's against the private interest in this matter, madam. He is otherwise for BPCL, yes.
That is what I'm saying.
Madam, here, madam, the on
Don't
appearance,
have the fun out here means it would lose everything. Anyways, what is your case?
but here, madam, we have applied for PESCO license, madam, explosive license, madam. Page third, is called by the Petroleum Explosive and Safety Organization license. madam.
Petroleum explosive license.
Yes, madam, page 13, page 39, madam.
That is required for continuing the district.
Yes, madam, page 39, madam.
Then
But it is deemed to be, madam, in force, madam. It is not yet, madam, renewed nor refused, madam. So as per Rule 55 of gas
you
cylinder.
submitted on 9/9.
Yes, madam, it is still in force, madam, in view of, madam, gas cylinder rules, madam.
Now, what is your case?
Now, madam, the IOCL, madam, asked me, madam, that they have maintained a system, madam, where, madam, they, after 30th of October, madam, it does not, madam, to receive, it cannot be up to date, madam. So they say that, madam, if we not submit it on or before 30th of October, madam, it will automatically, madam, they will stop supply of LPG cylinder, madam.
Now, tell me whether your license is valid or not.
Yes, madam, it is valid, madam.
Till
But page 38, madam. Earlier, madam, it was valid for 30/9/2025, madam.
so it is valid up till 39/2025.
Yes, madam.
That means as of now, it is not valid.
But it is valid, madam. It is deemed to be valid, madam.
How?
But the rule says, madam. Rule 55, my lord, sub rule, my lord, 5, my lord.
So you say that in terms with rule 55(5),
Yes, my lord.
it will be deemed to be valid
ma'am.
unless
It has been refused or, my lord,
it has been refused or renewed.
yes, my lord.
So therefore, under such circumstances, they should not,
Yes, my lord.
by
That is my-
virtue of this deeming provision.
Yes, my lord.
My lord, there is no cause of action for this application. My lord, the rule is very clear. Unless it is rejected by the, my lord, the explosives department, my lord, they continue.
Because he has submitted the renewal.
Yes, my lord. And rule 5 is very.
Because of their office, because of their officers, my lord.
No, because of what he makes
Yes,
a
my lord.
statement, we close it.
Yes, obviously, my lord.
Necessarily keeping it
Yes,
doesn't make
obviously, my lord.
sense.
Only our appearance, my lord.
Huh?
Only our appearance, my lord, we process, my lord.
Heard
If
Mr.
there is any, my lord, objection,
Counsel appearing on
if
behalf.
there is any objection or any problem, my lord, only they will know, will not know, IOC will not know. So far as IOC is concerned, my lord, we have not got any communication from the press.
No, anyway, you take an action if it is refused.
Yes.
Who are you? Why you are not taking action? Renewal?
On 9/9/2025, and it is under process now. It's not done. It is their apprehension that IOC and why this not coming.
Heard Mr. S. Bhattakur, the learned counsel appearing on behalf of the petitioner, Mr. So appears on behalf of respondent number 1 and 4.
Hope to wait, please.
Ankit Chaudhary, the learned senior counsel, appears on behalf of the respondent number 2 and 3. Mrs. U. Das, the learned additional senior government advocate, appears for the respondent number 5. The petitioner hearing petitioner has approached this court apprehending that on account of the renewal not being given to the petitioner of the license by the Petroleum and Explosive Safety Organization, the respondent number 3 and 4, 2 and 3 may take steps for discontinuing with the supply of liquefied petroleum gas cylinder to the petitioner in terms with the memorandum of agreement dated 16/10/2017. And as such, the petitioner has approached this court. The case of the petitioner in brief is that the petitioner is a distributor of the respondent number 2. And in that regard, a Indian liquefied petroleum gas distributorship bracket domestic and commercial agreement have been entered into by and between the petitioner and the respondent number 2. For the purpose of running such distributorship, it is necessary that the petitioner possesses a license issued by the Petroleum and Explosives Safety Organization. Full stop. The petitioner duly had the such license issued, which was valid up to 13/9/2025. Full stop. Prior to the expiry of the said license, the petitioner had duly applied for renewal on 9/9/2025. And in that regard, an acknowledgement have also been issued by the Petroleum and Explosive Safety Organization. However, till date, such license have neither been renewed nor such application have been rejected. It is, however, the case of the petitioner that if such licenses are not placed before the respondent number 2 within on or before 31/10/2025, there is a likelihood that the petitioner would not be continued with the supply in terms with the distributorship agreement. It is under such circumstances that the petition has been filed. Mr. S. Pottakur, appearing on behalf of the petitioner, submitted that in terms with the Gas Cylinder Rules 2016, it is the mandate of Rule 55, bracket 5, that upon seeking approval, renewal of a license or revalidation of an approval, it shall be deemed to be, the license shall be deemed to have been in existence till such license, such application is not rejected or not renewed. He therefore submitted that appropriate directions therefore be passed against the respondent number 2 and 3 to continue the supply in terms with the distributorship agreement pending such decision on the application filed by the decision in respect to the application seeking renewal of the license before the Petroleum and Explosive Safety Organization. For contra, Mr. M.K. Chaudhary, the learned senior counsel, appearing on behalf of the respondent number 2 and 3, submitted that the petitioner did not have a cause of action, taking into account that there is no decisions taken by the respondent number 2 and 3 not to supply the LPG distributorship and not to supply in terms with the distributorship agreement to the petition, in as much as it is deemed in terms with Rule 55, bracket 5 of the Gas Cylinder Rules 2016, that such license shall continue to be in existence till such decision is taken by the competent authority. Mr. So-and-so, appearing on behalf of the respondent numbers 1 and 4, submitted that the petitioner's license is, petitioner has submitted for renewal of the license only on 9/9/2025, and the same is in process. Considering the submissions made by the learned senior counsel appearing on behalf of the respondent number 2 and 3, it is the opinion of this court that the petitioner's apprehension considering the submissions made by the learned senior counsel appearing on behalf of the respondent number 2 and 3, it is the opinion of this court that the apprehension of the petitioner do not seem to be valid in as much as there is no decision on the part of the respondent number 2 and 3 to not supply in terms with the distributorship agreement dated so and so. This
16
court
till
further, this court further finds it pertinent to observe that in terms with Rule 55 bracket 5 of the Gas Cylinder Rules 2016, it is the mandate of law that a license shall continue to remain valid till if an application seeking renewal is filed and such decision is not intimated to the petitioner or that is not of its rejection. Considering the above, this court, in view of the submissions made by the learned senior counsel appearing on behalf of the respondent number 2 and 3, closes the writ petition with the above observations.
Daily list item 21.
May I please, Your Lordship? Lordship, the matter relates to non-payment of contractor's bill.
What happened?
The petitioner herein has not got the additional,
Got the money?
yes, Lordship, additional works bill he didn't receive, which is annexure number 4, 5, and 6.
Have you got
Is
the
the-
money or not?
No, Lordship.
You have filed cause title?
Yes, Lordship, for implement of respondent number 5, Lordship.
Okay. So now we have to issue notice, no?
Notice was issued on the last occasion, Lordship.
When?
11/9 of
Okay.
2024.
Now what is your stand?
Uh,
Madam, who is appearing for the deputy commissioner? What is your stand?
I'm told I'm newly implemented, madam.
Huh?
Leave is missing mathematics sometime, madam.
Okay, we have it after 2 weeks. Get your instructions. Ms. Yudas, the learned additional senior government advocate, submits that she is yet to receive the instructions from the respondent newly implemented respondent number 5. It's this matter again on 1st of December 2025. In the meantime, the respondents shall bring on record their stand by filing their affidavits on or before 28th of November 2025.
22.
What is this?
Lordship, the petitioner has received a dues, Lordship, with regard to his pending bills, Lordship. Nothing survives, Lordship.
You've got the money?
Yes, Lordship.
It has been submitted by the learned counsel appearing on behalf of the petitioner that the petitioner have already received the amount.
Yes, madam.
Ms. Yudas, the learned additional advocation, learned additional senior government advocate also submits that the petitioner have duly received and therefore there is no live cause of action. Taking into account the above, the instant petition stands closed as infructuous.
I'm up, Lordship.
23.
Yes, where is this matter? Where, yes, what is?
Already stock of cancelled this one, my sale notice at 29/11.
What?
29/11/2021, your lordship, item number 11, your lordship have already set aside the sale notice.
Okay, okay.
So pursuant to that, work order was given, it was stayed by this honorable court, your lordship.
Yes,
as it
so
has
nothing
followed.
remains.
I don't think, my lord.
None
But it's
appears on
there.
behalf of the petitioner on call. Gustav. Miss P. Via, the learned senior counsel who appears on behalf of the BTC, submits in that in view of the order passed by this court in WPC number as a repetition.
WPC number 6716.
Order passed in so and so in WPC number so and so. Nothing further survives in the instant writ petition. Inasmuch as this court have duly held that the sale notice dated 29
29/11/2021.
2021 is contrary to rule 32, 33 and 34 of the Assam Minor Minerals Concession Rules 2013 as amended by the Assam Minor Minerals Concession Amendment Rules 2018. Taking into account the above, the instant writ petition therefore stands closed. It stands closed and taking into account the above, the settlement so made on behalf of the respondent number four, private respondent is contrary to the provisions of law for which the same set aside in Bosch.
Lordship, I don't have the copy of the repetition. So respond number, I will not.
Private response Sailu. Impugn settlement order dated. Yes.
My lord, this is related
Oh,
to
this matter.
subsidies. So this can be take with 5950/22/23 or
This matter along with WPC number
5059.
5950/2025.
23.
2023.
25.
Yes.
Lordship, in this case, Lordship, we are seeking some instruction from our client, your Lordship.
Huh?
Seeking some instruction from our client, your Lordship, regarding
You
the
have a
present.
bad
update.
case.
Not exactly, your Lordship.
Then you have a good case. Then argue.
Lordship,
Why
what?
do you need an instruction? Instruction has been given. You sought for adjournment or for instruction on 28/8/2025, 24 until now you have not been
Lordship,
able to obtain
actually, within
instruction.
1 year, Lordship, what is the status of the
1
inquiry?
year you have not been able to obtain instruction and you
Since
can go.
suddenly it has come, Lordship, suddenly it has come, Lordship. Let me give at least 2 weeks time, Lordship, to seek some instruction from my client regarding the present status of the inquiry and the.
What inquiry?
There was an inquiry, your Lordship, with they have
Yes,
submitted
yes,
inquiry
Mr.
report.
Chaudhary, what is the matter about?
My lord, actually what had happened, the petitioner supplied vehicles to the forest department, a particular corporation under the forest department. Now, there was two tenders were floated prior to the instant tender. There was none to bid for it. Eventually, we bidded, we didn't have the experience, Miller. Supply order was given, we have made all the supplies. Half payment has been made. Now, half payment was withheld. There was some inquiry, Miller. There was some interdepartmental rivalry between some officers. We have been made this scapegoat. It's a fact. We supplied. There is no dispute on that count. 5-odd crore paid, 5-odd crore not paid. That is how the matter stood. Now, the issue was that we have submitted our bid with an experience certificate. We said no. We never claimed that. Lord, the fact of the matter is supplies were made. Now our payments were with him. We were just trying to invoke, my lord.
So they issued a show cause notice regarding?
That why the contract should not be annulled.
Means after the contract is over?
Yes.
Oh, what is this type of thing?
Lordship,
Half payment made.
half payment already been made, your lordship, today. Thereafter, on the verge of making the forward payment, there was an RTI application submitted by one person named Vijit Soikia. He stated that the petitioner to acquire the contract agreement, they submitted false documents. They submitted false documents.
How many years?
This RTI application was the 14/11/2022.
And when was the contract issued to the petitioner?
My lord, and a bid was invited in 22 and the LOA was issued in June 22.
And this application was 14/11/2022.
And vehicles were supplied
Yes.
by my lord October 22.
Thereafter, the inquiry was conducted, Your Lordship. At page 215 of our affidavit in opposition, the whole inquiry report has been annexed, Your Lordship. Here says that they have certain documents raise a suspiciousness of the petitioner supplying the experience certificate forged document. They say they have work experiences prior to this tender, stating that they are supplied to one SBI. Thereafter, when we conferred with the SBI, SBI said that no, we have no agreements with SBI that they have supplied anything to us.
Then
So that's the inquiry, this state inquiry status, I don't know what happened to inquiry status, Your Lordship.
My lord, we never claimed that we had
petitioner
experience.
was given the liberty to submit reply.
Yes.
What happened?
My lord, we never claimed that we have experience. We have clearly stated in paragraph 19 that we never claim. There was some interdepartmental rivalry, my lord, between the officers. We are basically trying to invoke section 70 of the Contract Act and the principle laid down by the Supreme Court in this FCI case, my lord, quantum merit. Since we have supplied, since you have availed the goods, part payment made, therefore payment should be made.
So you get to another 3 crores, 63 lakhs.
No, my lord. Our total value was for 10 odd crore. We have received 5 crore 40 lakhs.
Okay, so there is another bill.
Yes. My lord, the last vehicles were supplied in November.
When was the complaint filed?
It was in, my lord, impugn letter was issued on 26/1/23, so before that. Maybe it was the end of 22, my lord.
And then did they still continue to take your vehicles?
Yes, they're using it. There is no complaint on that.
How can you say? You see, you should have stopped immediately.
Yes.
Yes, they should have stopped immediately.
So, but you continue.
They continued, but
And then after taking it, then also.
Yes.
By way of your conduct. Yes, you may have terms to that effect. But then why did you accept it once you received the complaint? And you are yet to decide on the inquiry.
yes, Your Lord. So,
I understand, Mrs. Kohli.
No, no, এইটো প্ৰিন্ট কপি ডেলিভাৰী নহয় বছ নাই নাই লাষ্ট এইকেইটা দিছো 11
So you have challenged the,
page 160 my lord.
you have challenged the, what are you challenging here?
Basically this notice, my lord.
Because unless I set aside that notice.
Yes.
You cannot get the payment.
Yes, my lord, yes. So lordship, to kindly come to page 160. 160. Now that they're asking us a few documents we do not possess, my lord, because it was never our claim that we have experience.
So this is the document. Now you
Yes.
must have replied against this.
Yes. Thereafter, my lord, no final decision has been communicated.
Where you submitted reply pursuant to filing the petition.
Page 172, my lord. We confirmed that we have not issued any, submitted any letter on 6/5/22.
You have not received any letter.
Yes,
from
yes.
so-and-so?
Because the allegation was on 6/5/22. Letter was issued from our end whereby we proclaimed that we have got experience. Lord, it is possible that the officer who gave the contract, maybe he did something wrong. We do not know. But it is our pleaded case.
So
We
your
never,
documents, what you have submitted.
Yes.
Your tender document.
and that is, they would like to say those were forged.
Understood, whether it is, but that is that, but you say that you did not.
Yes, yes, we never claimed that you have experience. Because on 2 occasions prior to this, my lord, instant NIT, bids were invited, there was nobody to bid for it. Therefore, we are doing some other line of business, then they asked whether we could supply. Then we inquired from the market. I said, we can do it. And we have supplied in the same rate which is available, which is the dealer price. It's not that we have charged something more.
So what about the inquiry?
Inquiry, my currently come to page 215, the affidavit 215, page affidavit we are filing.
250?
215.
Forgery inquiry report on 12 of forgery of the documents in connection with the award of the SBL knowledge for supply of vehicles to Assam. It was on the genuineness of this order.
Please, please. And most interestingly, this so-called notice is dated 26th of January. He's the only person who was attending office.
How many people participated in the said notice inviting tender?
কোনো problem নেই। বেলেগে কৰা নাই না?
Mr. Chaudhary, after this inquiry report,
Yes.
was it subsequent to the writ petition or after the slide?
Subsequent.
Have you challenged this inquiry?
Inquiry is subsequent to the writ petition, my lord.
In fact,
Actually, my lord, whole allegation is on 6/5/22, we allegedly submitted an experience certificate. That is the bone of contention. And it is our specific case, we never supplied that.
No, it's okay. There is some finding. You have challenged this inquiry report.
Yes. Oh, no, the inquiry that we have not
they have
challenged.
not challenged the inquiry.
Because when we approached the honorable court, my lord, all that we had was the
In
this.
fact, two of our officers under scrutiny of the vigilance, Your Lordship. Two of the officers of the forest department, they're under scrutiny of the vigilance, Your Lordship. Charge sheet also.
Very good. They have to be charged sheeted, but the question is, Mr. Chaudhary, unless you challenge this inquiry report, the findings are goes against the.
Correct.
Don't you think so?
In fact, my lord, the matter has come up all of a sudden after a long time. We also lost track with the brief.
Because you sought for instructions in the year 2024.
My lord,
We are after 11
your
months.
lordships would kindly have the matter after 2 weeks, my lord. In the meantime, we.
So 15 months also no instructions. Because this inquiry.
No, we appreciate, my lord. Perhaps the inquiry report needs to be
Because this
challenged.
court cannot look into many aspects of the matter when these are findings of facts being.
My lord, our only case which we projected was that yes, there could be something wrong in the tendering process, irregularities, but no loss is caused to the state government. Yes, there are irregularities because without experience, how can the work has been allotted? Nevertheless, my lord, we made the supply at the same rate at which dealers does. And my lord, part of the bill was also received. Therefore, we were saying invoking section 70 of the Contract Act and the principle of quantum merit, please make us the payment. Because it's not a case where any loss has been caused to anybody. Lord, I'm sure, my lord, it's a rivalry between this gentleman who issued the show cause notice and the previous PD. There, my lord, batsmen, they were having some issues. Because this show cause notice was issued on 26th of January, my lord.
And
26th, Republic Day, my lord, everything is but close.
That's why he was.
And my lord, lord, we'll bring on record though that, my lord, we'll put a challenge to that and lordship will have it after 2 weeks, my lord. It's not that, my lord, we have a crystallized right or something. It falls within our lordship discretion, my lord. Our only case is since we supply, there is no complaint.
Before the civil court.
Let me,
Because these are certain-
let us file that, my lord.
Because these are findings of facts.
No, that, my lord, that, no, my lord, only question is, my lord, your lordship's power is wide enough, my lord, even a situation like this, to carve out an exception and remedy the situation. That is my only prayer. Yes, true. Normally, ideally, these are matters to be decided by civil
No,
court.
because there is a finding of fact in the inquiry report. Why I'm saying that? Because they say that on 6/5 so and so you have submitted certain documents.
Mhm.
You say that you have not submitted those. That's your contention.
My lord, we'll satisfy your lordship that we have not been able to. I don't think any process would be required to establish that. We'll do that. We'll bring a challenge to that also, my lord. Kindly give us 2 weeks time. No material.
And why is the fishery department involved? No.
Fishery
Where the last order says learned counsel for the fishery. department. On the materials on record, it is seen that there is an inquiry report given by the, submitted by, has been brought on record dated 10/2/2023, holding inter alia that the contract was awarded to the petitioner on the basis of some false document and false statement made by the petitioner. This inquiry report was brought on record on the basis of an affidavit filed on 13th of December 2023. The record further reveals that on 28/8/2024, the counsel appearing on behalf of the petitioner sought for instructions. Sought for time for obtaining instructions. It has been submitted by Mr. K. N. Chaudhary, the learned senior counsel appearing on behalf of the petitioner, that as the matter had come all of a sudden, the same matter could not be, the petitioner could, the counsels could not obtain the necessary instructions. In that view of the matter, this court adjourns the matter and fixes the matter again on 3rd of December 2025.
Sufficient time has been.
It is observed that without a challenge to the inquiry report,
Item 26.
Deeply obliged. Yes.
yes, non-payment. What is your instruction?
Receive my instruction, Your Lordship.
What?
Receive my instruction.
I can't hear you. Can you hear him?
Yes, instructions received, Your Lordship.
Instruction received.
It's time to file our.
What is the instruction? Yes, give it to us. File an affidavit. The learned counsel, and not by anybody else below the AO. This is what? Below the rank of a additional chief engineer. Affidavit. Ms. So-and-so appearing on behalf of the respondents submits that she has already received the parawise comments whereby the amount claimed by the petitioner have been duly admitted. So taking into account the above, this court would insist that such a stand be brought on record by filing an affidavit by an officer not below the rank of. What is this? Assistant chief engineer is there? Huh? I've never heard of, I've heard of additional chief engineer. The assistant chief engineer, water resource. Yes, finance. I've heard of assistant executive engineer, assistant chief engineer. When did it happen? Not below the rank of an additional chief engineer. Water resource. Instruction written. This matter again on 8th of December 2025.
Item 28 to 36.
What is it?
My lord, this also pertains to non-payment, but then there's a twist, my lord. The twist is that
Yes, what is this?
this pertains to non-payment. This petitioners, my lord, they had constructed this detention centers for foreigners, detected foreigners at Matia, Gwalpara. Now, the project was, because of the state importance, completed in a great hurry. And when the final bill was, my lord, work was completed and final bill was submitted, it had gone above, because of some variations and other factors, it had gone above the original sanctioned amount. Now, the Police Housing Board, who is my employer, they recommended that particular amount, saying that it is certified to be correctly executed. The matter was then sent to, my lord, the Home and Political Department, which is the parent department. Home and Political Department in turn, my lord, said that we want to re-verify if the work in excess of the limits were actually done. And they constituted a committee, my lord, through the Assam State PWD, and asked them to submit a report. That report also, my lord, has now come. That report has recommended the amounts with some variations, my lord. Some additions and some deductions are there. So the PWD has, my lord, recommended the amounts in our favor. Now thereafter, I am told, my lord, it has been sent to the finance now.
Yes, instruction, my lord.
In the chart, my lord, I have indicated the repetition numbers by hand. The additional amount required is indicated, my lord, in respect of all these 9 cases.
Then?
Right. PWD. PWD doesn't normalize it. One department or us? No, they are not.
So now it will be placed before the special standing finance committee.
So. We need some.
So we await that
My lord, my lord.
for some time.
Yes.
My lord, let us see, because it has just recently come, my lord.
Heard Mr. B. Pathak, the learned counsel, appearing on behalf of the petitioner. Ms. U Das, the learned additional senior government advocate, appearing on behalf of the respondents. Ms. U Das, the learned additional senior government advocate, has submitted that had placed before this court an instruction issued by the Joint Secretary to the Government of Assam Home and Political Department, wherein it has been mentioned that the revalidation proposal, as have been received from the Managing Director of the Assam Police Housing Corporation Limited, had been approved by the competent authority for placing the same before the Special Standing Finance Committee chaired by the Finance Minister of the state of Assam. She therefore submits that some more time may be granted in that regard. The instructions so placed before this court is kept on record and marked with the letter X. Taking into account the above, list this matter again on 1st of December 2025 for an update. You give this for future.
My lord,
Item 37.
deeply obliged.
Yes, what is this?
It's regarding non-payment of contractual bills.
How much?
Total bill amount was 10 lakh. Out of that, 7 lakh was paid. 3 lakh remains.
Iwa? No, agriculture.
Yes.
Where is agriculture? No agriculture today. Right? Wait, you are agriculture, Mr. You appear for agriculture? No. No. Who appears for Miss G. Bora appears. He's not here. None appears on behalf of the agricultural department when the matter has been called. It is seen that on the various occasions, on behalf of the agricultural department, the matter has been stalled, have been adjourned, so that the instructions can be obtained. Taking into account that none has appeared on behalf of the agricultural department, nor have provided the instructions before this court directs the chief engineer agriculture, who has to pay the director of agriculture, the director of agriculture, to appear through a video conferencing link before this court on 12th of November 2025 to give details as to provide instructions as to whether the petitioner is entitled to the amount of rupees 3 lakhs as claimed, and if so, when the said amount would be paid. Stop. Ms. G. Bora, the learned state council, the learned standing council shall apprise the director of agriculture about this order so that he can appear before this court at 10:30 AM on 12th, demand to the video conferencing link to be provided. Stop. A copy of this order be provided by the registry to Ms. G. Bora, the learned standing council of the agriculture, for doing the needful.
In item number 37, I have Mr. That's it, I have received instruction.
What is your instruction?
That's it, it is a admitted amount, what's it?
Where is the other side?
Give me 5 minutes, I will conduct a. Admitted amount we will pay, what's it?
আগৰ মেথডটো নেক্সট না? Hey, call the other side.
Got you,
Then only I'll choose.
got you. Help, please.
May I please also? As per the earlier order, the respondents supposed to file their affidavit, madam.
Work has been completed.
My lord, this is a ASCC matter. Counsel for the ASCC would be required. This matter relates to ASCC, my lord. Counsel is not here, my lord.
Where is the council?
My lord, I've just checked the cause list. I've just checked the cause list, my lord. Standing counsel ASCC is not reflected in that, maybe perhaps because of that. Just,
Who are you?
my lord, Transport Department, R1.
Work has been done. Period. Allowed for running for what period?
Lordship for 3 years.
Huh?
3 years. 3 years. 1 year gone by.
This was 21, it was given, then
Lordship.
it was renewed.
It was renewed.
But-
Since Lordship, since two
It is
thousand
not that
nineteen,
it was not given, given, but it was renewed, it seems.
renewed. But one side regularly tender has issued and other sides so far.
Like tender initially issued, I
Since,
think it was a tender issued initially.
since
and it was
19.
given, But the renewal was not without,
Lordship, since
renewal
19,
was not without notice.
Lordship, since 19, same party has
And
continued
renewal is given for what period?
for 3 years.
Where?
Lordship. The first, page number 23.
Where is it, 3 years? For 3. Subject to renewal in every 3 years interval with the following clause. My goodness, what is wrong with these people? None has appeared on behalf of the ASTC when the matter is called. The reason, you are, who is number 3?
Lordship, I am for 3 and 4, Lordship.
How did you get it?
Lordship, initially we got it in the year 2018.
But how is it renewal is given for every 3 years?
Lordship, renewal is given in the work order itself, Lordship. And Lordship, the prices are competitive, Lordship.
How is it competitive? Means how, you see the renewal order at page 23, it will says that it will be given renewal every 3 years interval.
Lordship, with an
What is this
enhancement
type of orders?
10%.
Okay. Okay. None has appeared on behalf of the ASTC when the matter is called. The reason being that the name of Standing Council of the ASTC have not been reflected. Considering the above. One Miss Ardeka was appearing on behalf of ASTC. Which Ardeka?
He was the earliest standing council for the SPC.
Now who is the Standing Council?
Yes, sir. Yes, sir.
Where is he? Huh?
Him someone.
Taking into account the above, list this matter on 3/11/2025, showing the name is of Mr. A. Samua, who is the Standing Council of the ASTC. On that day, we finish up this.
Lordship, obliged.
Pending item 37.
It will dispose of for you, admitted for you. 6 months.
39.
The private respondent has served a copy of an affidavit today. But I will file a rejoinder. I pray for
You file affidavit,
Yes, Your Lordship.
respond number 5.
Yes, sir.
They,
Today.
Yes, today I just received copy.
what do you have to say?
Because I will file a short rejoinder. Date may be fixed, my lord, because
What is the matter about?
matter is about, my lord, an award was passed, my lord, by the labor court. That has to be enforced, my lord. And
Labor courts award, what is the affidavit to be filed?
no, they have taken an objection on maintainability. They have taken an objection on the maintainability part.
What is there to file reply?
Lordship may fix it for admission, my lord. Can be, lordship may.
Labor court matters needs to be finished up as early as.
Yes,
possible.
no, that is absolutely. And
Otherwise, it becomes a stale dispute.
no, in very simple words, you know, this man has been struggling for his service benefits since 1990, my lords, and he is now more than 70 years old. The only issue is that, my lord, perhaps.
You want to further delay.
Sorry, me.
You want to further delay.
No, my lord, I don't want to delay it. I'll not delay it, my lord. I'll argue on the point of maintainability. It's a point of law. Lordship may hear it, decide the matter.
Records are here.
My lord, I.
Recordation is, huh?
No, record perhaps may not be.
Without the record, we cannot finish it. Huh?
No, my lord, it is not the correctness of the award per se that is under challenge. It is only the enforcement part. Section 33C. of the Industrial Disputes Act. Neither have they challenged the award in any forum. Award is attained finality, my lords.
Award is not challenged.
No. I am the workman, my lords.
It's for implementation of the. award.
Implementation, my lords.
Then why you are here?
Because, my lord, I have twin remedies. My lord, I can, here I am seeking a.
Remedy is there.
No,
Why you are
remedy-
not there?
No, my lord, here also and there also.
No, not here, there.
No, there, my lord, earlier, my lord, there was.
Show me, as per the Industrial Disputes Act, this court has the remedy.
Yes, yes, this court, my lord, this court can, no, my lords, here, my lord, the remedy, the award is to be enforced by the deputy commissioner, my lords. Now the,
As per, if it is an award passed by the Industrial Dispute Act.
yes,
I
this is
think
not
the
physical-
enforcement is very strong, is
No.
much better. Why you are here?
it is there, my lord, but the question is that the award, the labor court has become functus officio, labor court has forwarded the award to the labor department. And labor department is to forward it to the district commissioner concerned.
No, I'm not on there. Once, has the award been notified?
Yes,
Okay.
notified in the gazette. my lord.
Let us see the labor court time. Industrial Dispute Act. A settlement shall come into operation on the date as is agreed upon by the parties to the dispute, and if no date is agreed on the date on which the memorandum of settlement is so and so. Such settlement, an award shall, subject to the provisions of this section, remain in operation for a period of 1 year from the date on which the award becomes enforceable under 17A. So it may reduce the period and so, provided that when appropriate government before expiry of the sale extends the period of operation of any period not exceeding 1 year in month. Shall apply to any period to hold out.
Because the labor court forwarded the award to the labor department, my lords, in 2022.
Now, the Labor Department have forwarded to the Deputy Commissioner.
Yes, no, my lord, that we do not know. I applied under the RTI Act but received no information.
What is that?
Mention matter, filed by the Honorable President Office and Ministry on respect of case number 33 C2, 1 of 19 and RT application has been forwarded to the Assistant Labor Commission at Tesco for further necessary action via office letter number successor dated 2/4/2024. The aforementioned matter does not come under the jurisdiction of office and the appropriate authority for this matter. The office of the Assistant Labor at Tesco for necessary action.
You filed the application within 1 year there.
Yes. And my lords, the application was decided and by page 89, my lords, this was forwarded. The award copy was forwarded to the labor department. But thereafter, my lords, what has happened, my lords, what has transpired, that we do not know, my lords.
So this was forwarded to the Labor Department.
Yes, labor department is supposed to forward it. And
Labor Department is the appropriate government.
Yes, my lord. They are supposed
Not
to
to
forward it.
anybody else, it means the appropriate government.
Yes,
Then the appropriate government has to send it to the collector.
a collector, the district
Now,
commissioner.
the collector have not taken action in
No,
terms of
that is what,
33C.
no, we have no information.
Why haven't you not taken action against them? Have you challenged the award, madam?
Your Lordship, the proceedings as far as the award is concerned have been concluded. The award which is passed, which is under question now, I'm not sure if it'll be appropriate for me to make submissions at this point, Your Honor, because none of the reliefs which have been claimed with the petition are directed against us. Our submission in the affidavit in opposition is that the petition is premature because they have not exhausted their alternative efficacious statutory remedies.
The remedy they have applied.
Yes, I have
within
twin
1 year.
remedies, my lord.
They have applied.
I have twin remedies. One remedy is to go through the labor code, but in this case, labor code, my lords, for all purposes has become functus officio. It has forwarded the award to the,
No, read 33C1.
yes, that is the execution part. Execution is also done. Now,
We are
after
concerned
the,
with the execution.
yes, that executed, that award to be executed in the form of a certificate has to be sent to the collector, who will then recover
Been
it.
sent, no, the labor code, kindly see this,
Lordship.
33C. Where any money is due to the workman from an employer under the settlement or an award or under the provisions of the workman himself or any other person authorized by him in writing or in the case of Iman, without prejudice to any other mode of application recovery, make an application to the appropriate government
Yes,
for the recovery of the amount due to him. And if the appropriate government is satisfied that any amount is due, it shall issue certificate to that amount to the collector, who shall proceed to recover the amount in the same manner here, provided that every such application shall be made within 1 year from the date on which the money is due.
yes.
Did you file the application before
That
the
I-
Labor Department?
Not the labor department. In the labor court, I
What do you mean
applied.
Labor court. Labor court is different. Labor court is under section 7A. You should have approached before the Labor Department.
Because the approach under section, when the award is already forwarded, my lord, all that is to be done in this case is that the
When
The
there is a
certificate has to be
provision
issued.
out there, when there is a provision where is entitled to receive any employee for which is capable of being computed in terms of if any demand question arises a demand, then the question may arise subsequently rules that may be framed be decided by such labor court as may be in the behalf by within a period of not like provided that with the presiding officer considers necessary to be made for extent such way. So here you applied under what provision?
my lords, I made an application under 33C2 before the labor code, which is that page.
Where
my lords,
a workman
69.
is entitled to receive from the employer any money or any benefit which is capable of being computed in terms of money. And if any question arises as to the amount of money due or to the amount at which such benefits should be computed, then the question may, subject to such rules as may be, so and so be decided by the labor court.
Yes,
If
that-
any question arises, here there is no question arises.
The
Does
question-
any question arises?
Yes, the exact award, my lords. The amount of the exact quantification was done by the.
Labor did not do it.
It did, my lord, it did. That is
No.
the application that we filed. Yes, my lord.
What did the labor court do? Let's see.
My lord, there are two awards here. My lord, the second application under that is the application under 33C2, that is at page 69, annexure 5, my lord. This was the application, my lords, in which I quantified the, my lords, award, that this is the amount that has to be, is due and payable to me.
It's okay. Then what happened? What
Then,
did the labor court do?
Yes, the management also filed its WS in that, my lords, proceeding,
This
and
is the award.
thereafter, my lord, page 84. That is the decision of the labor court under section 33C2, my lord.
So he is entitled to realize this amount which comes to rupees 6 lakh so and he is also entitled to interest from 2018.
Yes,
So this amount has been given.
this amount is.
So then what happens
Then, my lord,
is
page
once
80
this is being given,
Yes,
specified in the behalf by the appropriate government within a period of not less than a year, provided that where the presiding officer consider it necessary for the purpose of computing the money well spent. So this has been done.
This has been done, my lord. Now,
That whether as the case may be specified in that behalf by the approval within a period of not exceeding a month. Then what is the decision there shall be forwarded by it
yes,
to the appropriate government
89.
and any amount found due by the labor code should be recovered in the manner in so and so.
yes.
So therefore now it has been forwarded to you. Why you are not taking action in terms of this? No, madam, kindly see page 89. This has been forwarded to you, that award, computing how much the petitioner is entitled to. Then why you are not taking action in terms of the 3364? Huh? Then this award, the second award has also been notified.
Yes, it
Didn't
has
it?
been notified. That
And-
is there at page 90, my lords, annexure 9. This is the gazette notification, page 90, my lords. And this was, my lords, done. Thereafter, my lords, I've been approaching the management concerned, my lords. I've been approaching the management, my lord, but the stand of the management, which they, my lords, say,
But the question is, isn't it the duty of the, what do you call that, appropriate government, the collector to do the needful?
Yes.
Because isn't it the mandate that you have to follow as per one?
yes. My lord, the labor department, my lord, whether the labor department has at all forwarded it to the deputy commissioner or not, my lord, that is the crux of that.
Why they have not done?
Because, my lord, the process is that, my lord, because, my lord, the process will be that the deputy commissioner will issue them notice, the management, they will have a hearing, they are entitled to a hearing, and then the recovery will be made.
They will initiate proceedings, Bakijai proceedings.
Bakijai proceeding.
Let me make a clearer order so that we get better instructions.
Gotcha.
Heard Mr. A. Ganguly, the learned counsel, appearing on behalf of the petitioner. Ms. Udas appears on behalf of the respondent number
5 years.
1, 2, 3, 4. Ms. So-and-so appears on behalf of the respondent number 5. The issue involved in the present proceedings pertains to enforcement of the award. In terms with section 33C of the Industrial Disputes Act 1947. A perusal of the material records reveal that pursuant to this industrial dispute having a reason, the appropriate government, that is the government of Assam, had issued a notification under section 10, 10, notification is done under,
yes,
under section 10, and made it, had issued a notification dated 23/3/2000, making a reference to the learned labor court. Pursuant thereto, a reference case being 1/2001 was registered before the learned labor court, Guwahati. The record further reveals that by an award dated 27/4/2009, the learned labor court And that the management was justified in terminating the services of the workmen at the expiry of the probation period, and also in that premises, the workman was entitled neither to reinstatement nor backwages and other benefits. The petitioner thereupon challenged the said award dated 27/4/2009 by filing a writ petition before this court, which was registered and numbered as WPC number 5165/2009. And this court, by the judgment and order dated 10/11/2017, had set aside the award dated 27/4/2009 in reference case number 1/2001 and directed the Learned Labour Court to adjudicate the matter afresh by retaining the evidence already adduced and if necessary by allowing the parties to adduce further evidence. Pursuant thereto, the Learned Labour Court passed another award on 22/5/2018, whereby it was held that the question of reinstatement of the petitioner did not arise on account of the overage, but the petitioner was entitled to full back wages from the date of termination till his employment in Bihaliti state in the year 2001 as pharmacist. The management, that is the respondent number 5, was directed to pay full back wages to the workman from the date of termination till his appointment in Bihaliti state as pharmacist. Pursuant thereto, taking into account that there was a requirement for a quantification of the amount, the petitioner filed an application in terms with section 33, capital C, bracket 2 of the Industrial Dispute Act 1947, for short the Act of 1947, seeking appropriate quantification. On the basis thereof, a case was registered before the Learned Labour Court of Assam, being case number 1/2019. The respondent number 5 duly participated in the said proceedings by filing the written statement. Subsequent thereto, an award was passed on 29/2022 by the Learned Labour Court, holding inter alia that the petitioner herein was entitled to an amount of rupees 6,42,809.26 paisa, along with interest at the rate of 9% on the said amount from 2/5/2018 till realization. This award so passed in terms with section 33 bracket C, 33C bracket 2 of the Act of 1947, thereupon was forwarded to the appropriate government in terms with section 33C bracket 2 of the Act of 1947 by the Registered Labour Court. However, there was no action taken by the appropriate government in terms with section 33 capital C bracket Roman 4 and bracket 4 of the Act of 1947, and it is under such circumstances the petitioner is before this court. Isn't that the case? Ms. Yudas, the Learned Counsel, though notice have been issued in the instant matter as far back as on 6/12/2024, there is no instruction placed before this court as to why the appropriate government till that have not taken any action to proceed in terms with section 33 capital C bracket 4 and read with section 33 capital C bracket 1 of the Act of 1947, thereby directing the collector to recover the said amount from the respondent number 5 as areas of land revenue. Full stop. Ms. So-and-so submits that Miss Udas, the learned additional senior government advocate, submits that she requires 2 weeks' time to obtain the necessary instructions. First, taking into account that the petitioner has been fighting for his dues since 2001. This court directs the state respondents to apprise this court on 14th of this November 2025 without as to what steps have been taken in terms with the aforementioned provisions. List accordingly.
Your Lordship, the affidavit which has been filed with Government.
Affidavit. Repeat now.
Item A.
Okay.
All Assam Fair Price Shop Dealers Association. What is
Yes.
this?
Yes, Your Honor.
What do you want?
Your Lordship, this writ petition is with regard to the non-payment of the statutory margin payable to the fair price shop dealers under the NFSA and the.
Yes, why you are not paying?
You have filed the affidavit in our affidavit, you have said that whatever is earmarked for them, it has been paid.
Huh?
Whatever is payable to them, it has been paid. The amount differential as shown by them is not payable to them. Well, kindly take up our affidavit.
You have filed reply?
Yes, Your Lordship, we have filed a rejoinder. Your Lordship, respondent number 1 has also filed their affidavit in opposition. We have received a copy on Friday, last Friday. We'd like to file a rejoinder to that affidavit in opposition.
And against their affidavit?
We have already filed a rejoinder.
Because they get the money from the central government.
Yes, Your Lordship.
So they have to pay.
Yes.
If you are entitled. What do they say? You are central government.
Yes. Good and see.
Are they entitled? You will say we only reimburse.
As per our fixation of rate is under state government.
Understood. So what the state government say, you reimburse.
He has not started.
Who?
State government has started any copy.
You have to also understand you are not paying, so the state government doesn't have the money to serve a copy to you. You have money.
Money we have.
So and so appearing on behalf of the respondent number 1 submits that the copy of the affidavit filed by the respondent number 2, 3 and 4 have not been received by him. The learned counsel appearing on behalf of the petitioner further submits that the respondent number 1 has filed an affidavit on 24/10/2025 and the petitioner would like to file a reply.
Your Lordship may grant 2 weeks' time, we can. In 2 weeks. A date may be fixed.
Why?
Your Lordship, these are fair price shop dealers, so it's there's an urgency.
Why should I fix a date? You have not filed your reply. Anyways, list the matter on 8th of December 2025. In the meantime, reply be filed by the petitioner.
What you want?
You give a copy to him. I don't want to mention it. Outstanding, non-payment.
Instructions is awaited, Lordship. So it is admitted, Lordship. The instructions is awaited.
Instruction awaited. When are you going to get it?
2 weeks, Lordship.
Okay. The petitioner herein has filed a writ petition claiming that an amount of rupees 10,47,280 is outstanding. In that regard, notice was issued on 19/3/2025. Even after the passage of 7 months, the respondent health department submits that there is no instructions. It appears that the respondent authorities have not taken the benefit of the respondent of the advocate of the services of the standing counsel and have not provided the instructions. Considering the above, list this matter on 1st of December 2025. It is observed that if the affidavit is not filed by the respondent on that said date on or before 28th of November 2025, the Director of Health Service, who is to pay? The Director of the respondent number 2, who is to pay the money?
Yes, the screen number,
Director.
not director. Medical college losses.
Superintendent,
Superintendent.
the respondent number 4
Yes.
shall be present before the court through the video conferencing link to be provided by Ms. So-and-so, D. Bora, the learned standing counsel of the health department. Also, it is observed, it is clarified that in the circumstance affidavit is filed, the presence of the respondent number 4 would not be required.
42.
Yes, what is this? No affidavit filed.
Well, if petitioner filed one IA, in the interlocutory application, we filed the affidavit. There is an order in that, Lordship may kindly take up 7/8/25. There is an order.
7/8/25.
1557 of 2025.
You are asking IA এখন চাও?
মস্ত লম্বা order. Order only.
Here, we filed our affidavit.
না, কোন নাই আছে?
Yes. So you were asked to select.
Well, that has been done. I have received the minutes.
Mr. Chaudhary, you have assailed the actions on the basis that it has been given.
No, we
as
no,
a-
no, Milord, we challenge an NIT. This was an internal, interregnum, this arrangement was going on.
Oh,
We challenge the NIT. NIT has been stayed. The reason is very simple, Milord. Under the Act, authorized agency is defined. What the government is doing, Milord, they are engaging private contract against the statutory mandate. Now they cannot select like this. Their main NIT is there. They should select from the NIT. Idea of this order,
so this order of 7/8/2025.
yes,
Therefore interferes with such action,
yes.
and thereby giving them 2 months time.
Actually, what had happened, Milord, the original NIT was stayed. From 23 onwards, some private contractors were performing this job. So the purport of this order was, you do away with this engagement of private business and engage some authorized agency. But engaging authorized agency cannot be at the discretion of the deputy commissioner. You should have taken the tender to the logical end, which is the ultimate subject matter. Well, it's not that these deputy commissioners are not aware of the legal position.
No, now they have taken some decision.
No, we do not know, Milord, what decision they have taken.
After.
But my humble submission is, Milord, even that decision can be done only through tender.
Financial,
Ah.
1610. What happened in the 1610? What happened on 1610?
In fact, in the minutes, I have given the minutes on 1410.
Understood, what,
Yeah,
the financial
accordingly-
bid was to open
Yeah.
on 1610.
Accordingly, they have taken it.
We are on 3010.
Yes, subsequently, the selection has been done and it has been granted to this particular winner.
Who?
At page number, first page, serial number 1. One cooperative.
Amor
cooperative society has
Dukan
been selected.
Consumer Welfare Cooperative Society.
Yes, they have been given the work.
How do you know?
I have telephonic instruction.
Then,
This has.
so they are an authorized agency.
Not.
We do not know, Milord. But what about my candidature? I am also an aspirant.
Ah.
Whether my case was considered.
So you considered in terms with this notice inviting tender which has been stayed?
Yes.
Then how did you consider? Was it vacated?
No,
No, how did you consider?
Subsequent to the order of 7/8/2025.
Within 2 months, you were allowed.
Lordship has directed that in the interim, we have to give the work to the cooperative society, which is an authorized agency. Accordingly, the deputy commissioner has undertaken the process and pursuant to this process, the particular cooperative society has been allowed to run. And in the final petition, Lordship may kindly give some time, my lord, I have also.
The next 2 months, he tender from satisfied.
In the main petition, my lord, we will file our response, my lord, till the.
Oh, my lord, can I make one
It
stop?
appears, no, Mr. Chaudhary, as I could understand. You challenged the NIT.
Yes,
NIT was state.
state,
While the stay was going on, they were operating through some private contractor.
yes.
The earlier, whoever is running.
Somebody,
you are-
you filed an IA.
Hmm.
Court interfered with these private contractors.
Arrangement,
And directed them that within 2 months we are permitting that,
Ah.
but immediately thereupon you take some action by way of an authorized agency.
yes.
Now they are taking a stand that for the interim.
All right, they have, for the
in
interregnum, they have done it very well, my lord. Now let the original tender be settled within a period of 2 months. Let this interim arrangement which they have made continue for 2 months, where our cases should be considered and private contractors should not be considered. That is what. Lordship can dispose of the matter.
So therefore your repetition
Ah.
means the fact that you are giving up your challenge to the NIT.
No, I'm not giving up, my lord. No, I'll give up only to the extent because they have accepted the position, therefore they have given it the work to an authorized agency. But this is an interim management, very well. Because administration has to run, my lord, because these are food meant for needy people, lordship will not interfere. But within 2 months, my lord, let the original tender be settled without giving the work to a private contractor. That's all.
No, I think you need to bring on record these minutes as well as the financial bid and the order by which you are going to give it, have given it to this. organ. Once you give it, then we will pass the order in this. I'm saying that this particular period will be there, you finalize that. And you finalize this tender.
Original tender.
Original tender, and he gives up his claim in respect to the challenge to the original tender. I think this is the, so you file the affidavit by Saturday, we take it up on Tuesday, finish it. 2 minutes.
By Monday, I'll file. By Monday.
You file it by Monday, we take it up on Thursday, and finish it. Mr. Dina, the learned senior government advocate, appearing on behalf of the respondent, submits that in pursuance to the order dated 7/8/2025, passed in IH civil number 1557/2025, the respondent authorities have done away with the private engagement of the private contractor and have till the pendency, during the pendency for the, have for the period during the pendency of the instant with petition appointed one or more a cooperative society in the name and style of Amor Dukans Consumer Welfare Cooperative Society Limited, Rongakorra Road, Sukia. It is the opinion of this court that the said aspect be brought on record by filing an affidavit, thereby including the minutes of the technical bid as well as the financial bid, and thereupon, as well as the order of such appointment. Mr. Dina submits that the said affidavit will be filed on or before 3rd of November 2025. List the matter on 6th of November 2025 at 2 p.m. on which date an attempt shall be made to dispose of the petition.
Diploma.
43.
Oh, Mr. Hawk, where is he? Ah, there. Seeing the name of the petitioner, I was searching for the lawyer. Yes, what is this? Oh, that matter. Why haven't you filed that affidavit?
Lordship, we have sent it for vetting, but we've been informed DFO is out of station.
You're saying it's because of some green.
Yes, the NGT
Green
is going
tribunal
and
order.
recently I just received one instruction report from the range officer submitted to DFO. Your Lordship, regarding stone crusher.
File your affidavit when?
Lordship,
7
after,
days.
2 weeks, because DFO is out of station, Your Lordship.
Okay, Mr. R.R. Gogoi submits that the affidavit has been sent for vetting and as such could not be filed. List this matter on 17th of November 2025. In the meantime, the affidavit be filed on or before 14th of November.
Right. Obliged, Lordship. Obliged.
44.
Salmia. Oh, Salmia's case is here, tender value.
My lord, some time may be granted to file a reply, my lord. They have filed their affidavit. It's not on record, my lord. Affidavit is not on record.
We've already filed.
Yes.
But some time is required to file their reply, my lord.
They file affidavit?
They have filed the affidavit. The
Yes.
affidavit is not on record, my lord.
So, Mr. As Doctor Standing Counsel of the PNRD, you have also filed. As well as Mr. S. Count appearing on behalf of the private respondent submits that a new affidavit has been filed. The learned counsel appearing on behalf of the petitioner submits that the petitioner would like to file a reply.
What?
This, how much?
1 week time, my lord.
Reply. Taking into account above, list the matter on 12th of November 2025. In the meantime, the reply be filed by the petitioner. That is pertaining to that, no?
Settlement of.
The petitioner did not submit the police verification.
Yes, yes.
File your pleasure.
He was on the
Item
question of
63.
petitioning. Both of them were equal.
Equal, your lordship.
And he did not submit the police
Yes.
verification.
Yes. Obliged.
Yes, Mr.
File
Sahab.
our affidavit, my lord, which is on record. Reply, reply. My lord, today, in fact, my lord, what happened, we filed a writ appeal in July. It was listed, we filed a writ appeal in July against the rejection of the interim order. And today division bench passed some order, my lord. I think it may be fixed on next week, my lord.
What does the division bench pass?
Division bench allowed us to, my lord, participate in the tender, my lord.
Eight.
And my learned friend also filed the affidavit, my lord, recording the document, my lord, that copy of the agreement.
So the blacklisting has been stayed.
My lord,
That has not been stayed.
No.
If it is not stayed, how can you participate? Wouldn't that be
that
contrary
is,
to
my
the
lord, order has been
conditions?
passed.
Otherwise, my lord, honorable court said that you can participate now till during the pendency. But my lord, that will not affect the merit of the case.
That will be considered by the single bench.
State, but that was the line, specific line.
But wouldn't it be very difficult? If a blacklisting is not stayed, the terms considers that it is no.
Correct, my lord.
Good.
Very reluctantly,
You-
finally, the
You have a better now, therefore, whenever I say that I'm not granting an interim order, you may have a more merciful judges in the division bench.
No, my lord, that was not passed by your lordship.
Huh?
Not by your
No,
lordship.
no, obviously, this is, I know, this is by Justice Goswami.
Ah, yes.
But the fact remains that there are more merciful judges in the division bench.
At the last moment, that otherwise honorable court's view was that, my lord, they will have to withdraw it, otherwise it will be dismissed. That was the initial view of the.
Which
division.
one?
Finally, in the writ appeal.
And not yet filed.
The
No
written
activity.
order will have to be placed.
So you have filed reply.
Yes, my lord. That is in the record.
You have
And,
not come on record.
and that agreement will be filed by them, my lord.
Allowed to participate, participate. In the
Okay.
division bench.
No, that is another, my lord.
My lord,
My
finally
lord,
here that-
this matter is to be heard, my lord.
Satisfy-
Huh?
This
They will
matter.
satisfy your lordship on that point, my lord, any day, not next week, thereafter.
But Mr. Gogoi, do you understand the fact that the number of cases I am fixing these
I
days,
understand.
by any chance, I am not here from 10th, which may be very good for some of the petitioner councils. But
No, they
That
can give
is-
benefit available.
the pressure which the next judge would have to endure.
So after 10, my lord, any day when this benefit available, lordship will.
No, no, when I'm not there.
No, no, your lordship is there, my lord.
Therefore, it would be very difficult. I have speak so many matters in.
Not for.
Okay, list.
Initially, when the bench is available, we'll wait.
No, no, no. Okay, we have it on 13th of November.
Well,
Pleadings are complete and both the councils appearing on behalf of the party have expressed urgency in the matter, as this matter pertains to a tender process,
Blacklisting them.
pertains to blacklisting, which is affecting the right of the petitioner to participate in the tender process. Considering the above, list this matter on 13th of November 2025 at 2 p.m. for final disposal.
64.
my lord, in this case, my affidavit is almost ready, my lord. I'm praying just for 10 days time to file affidavit.
If it is almost ready, why 10 days?
Lord, some instructions.
I would have understood if it is not ready, then it is different. There is a stay order.
Well, 7 days, 7 days, man.
No, there is no any stay.
7 days, man.
Now, here you say that this was a private market, if I remember earlier.
Yes.
But why wouldn't you file the affidavit?
My lord, 7 days, my lord.
Okay, Mr. P, Mr. S. Doctor, Standing Council of the PNRD Department submits that the affidavit has been set for vetting and will be filed on or before 7th of November 2025. List the matter on 12th of November 2025 for admission.
My lord.
All right.
65.
My lord, they have filed the affidavit. If your lordship will see, my lord, our digital signature is there, my lord. Digital signature is there in the certificate. In the affidavit, your lordship may come, my lord, at page 81 of the tender document, that certificate is there.
Yes.
Please, Your Lordship, and kindly come to page number 65 of my affidavit in opposition, madam. Paragraph 5.
Page 65.
Yes, Lord.
Yes.
Paragraph number 5, madam.
Huh?
Paragraph number 5. The appointment made in paragraph 5 of the requisition the deponent denies.
Wait.
Yes.
Yes.
Here, my lord.
The deponent begs to state that the petitioner admitted in his statement that the uploaded compulsory certificate is tempered modified as compared to the standard fluence of the tender demand. The need of fluence of dated tenders are compulsory required to submit. Without the offer will be summoned. Hence, it is evident that the annex of 5 is a compulsory document and any deviation fluence would lead to rejection. Online certificate as mentioned by the petitioner is not a certificate, but format provided in the tender document for the guidance of the year. The tenders are required to submit all certificates and designated places. That is point number 1 under the technical so and so. Moreover, the copy of the declaration by the petitioner said online. A copy of the declaration by the petitioner. Said online certificate with signature for legal or
Now kindly come page number 81, my lord. 81, my lord. It is a tender
81.
document. Page 81, this is the certificate, the next are 5, my lord. This is the format, my lord. This is not the, and they have to upload this certificate in page number 82, 1, my lord. Kindly see. 82, number 1, my lord, point number 1. They have to upload this certificate, annexure 5, my lord. Which they have stated that this and this is the certificate they have submitted, my lord. This is in page number 81, my lord. This certificate with signature they have to upload in page number 82, column number 1, my lord. But this did not attach.
Submitted reply?
No.
You don't want to file reply? They directly against you.
Well,
You don't have a case otherwise. I was a bit surprised because when I passed the order, thereby not granting the stay on 26/9, I made it very clear that when I peruse this annexure 9 and
Yes, sir.
it appears therefore, so when you said that the certificate was there, you
Yes, sir.
So, it is seen that the affidavit in opposition has been filed by the respondents authorities on 24/10, na?
Yes, my lord.
24/10/2025. The petitioner herein submits that the petitioner would like to file a reply. To list this matter again, how much time? 1 week.
1 week.
List this matter again on 17th of November 2025. In the meantime, reply be filed.
Must have been.
For orders item 46.
Lordship, I am appearing for respondent number 3, Lordship. Since one secondary Akash DP said Bihar election.
What? Bihar?
Bihar election.
Since the last year order of it.
Yes, I mean, the 14 Lordship, the list after 14 Lordship.
In the Bihar order to us, no? That day I passed some order, na?
28.
This person pertains to Akash Deep. Akash Deep, na?
Yes, Akash.
Is so and so appearing on behalf of the alleged contemner submits that he has been sent to Bihar on account of election duty in respect pertaining to the Bihar Legislative Assembly. Ms. R.B. Bora, the learned counsel, further submits that he would be only the alleged contemner would be available on 14/11/2025. After 14/11/2025. Accordingly, lists this matter on 28th of November 2025.
47 also.
The affidavit will be filed without fail on or before the next week.
47.
Similar plan.
Same.
Similar plan.
This is for respond number 3. To respond number 3.
In these cases, your lordship, I need to substitute the respondent number 1.
You have filed an application.
No, your lordship, I need some time, your lordship.
When were you permitted to do so?
The order, your lordship.
260.
Oh, it is.
26.
26 to 25, your lordship.
24, you have been permitted to do so, not prior to that.
No, 26 to 25, your lordship. 26 to 25.
No, when were you asked to do so?
26, your lordship. 20 June 2025, your lordship. The person is.
You
said,
cannot
your
file without 6 weeks, whatever may be. Okay. Item number 48 to 51, taking into account the submissions made by Mr. T. Deori, that there will be, that the petitioner would be required to file fresh application seeking impediment. List these matters only upon application for impediment being filed.
52.
Deeply obliged, your lordship.
Yes.
Here, the amount has been paid as per my instruction. And I have asked the counsel for the petitioner also, she confirmed that she has received the amount. But I don't have the written instruction.
Mr. Nath, if I could have closed it, I would have been very happy. But I can't close on just on words, it has to be in black and white. And that too when the petitioner is not there.
I have spoken to her, she said that yes, they have received the amount. Along this.
And contempt I can dismiss for default also. So Mr. Dean, the learned counsel submits that to his information, the amount have been duly paid to the petitioner. Full stop. The learned counsel, it is the opinion of the court that the same should be, the said aspect be brought by way of instructions so that this court can pass appropriate judge orders.
I think
When did
53
you get it?
Next Friday.
Huh?
Next Friday,
Next Friday.
7th.
This is matter. So list the matter on 7th of November. Yes.
Item 53 to 57.
Lordship, are we allowed to file an IA for implementation of
We
the
filed
present?
or not?
That was not filed, Lordship.
A to 48 to 51 type order. Huh? In Manjaran, Nam to make it on Nam to keep it.
Lordship,
Will
obliged,
be listed only after you file.
Lordship.
Yes, 58.
That amount is calculated at 9,64,000 and
I did have 58.
additional farm improvement is received, it will be discussed.
Lordship,
Yes, the matter stands in John to 2910. What is the case? What is
Lord-
the instruction?
Non-payment of contractual bill, Lordship. As per last order 23rd of June, Lordship, the commissioner undertakes to directed the respondent 2 and 3 to comply the order, but till date, Lordship, no complied, no payment has been made.
They have done their part, my lord. Thereafter, commissioner and my lord had issued the sanction the amount, my lord. Now system has been upgraded, my lord. Therefore, 4 weeks time is required to release the payment. Already sanction has been made.
Yes.
This is the.
Mr. S. Dutta appearing on behalf of
Respondent number 1.
respondent number 1 and Miss Yuda, the learned counsel appearing on behalf of
Number 2 and
2 and 3 submits that the necessary formalities for the purpose of making payment to the petitioner have already been carried out by issuance of appropriate necessary sanction. It is also being submitted that for the purpose of dispersal, a further 4 weeks' time would be required. List this matter on 28th November 2025 for an
Or in the
update.
month of December, my lord.
1st of December 2000.
Lordship, Lordship, they have, here, Lordship, amount has been shown only 9,50,000, but
That is
I am
admitted.
entitled, I am entitled, Lordship, 25 lakhs, 25 lakhs 74,000. That is the admitted liability, Lordship. Lordship, I don't know why they have,
After the physical inquiry, my lord, it was found that admissible is 9,54,000.
that's the art fee and all money. So, inquiry was conducted.
Lordship, direction was to re-verify the pending material bill. If any outstanding, Lordship, then make payment, Lordship. And now they have come with 9,54,000 only instead of. My initial claim is 28 lakhs, Lordship, out of which, Lordship, 2,52,000 bill amounting to 2,52,000, they say is a non-permissible word. Lordship, I am not asking for that, but the other pending material bill amounting to 25,74,000, that should be paid. The bill has got final by uploading in the MIS, Lordship. They have admitted in the affidavit by respondent 1.
We'll see.
Lordship,
You get the memo, huh?
Lordship,
Then we take it up.
Lordship.
Whether they have mentioned in the affidavit that about the 9 lakhs, not by way of this step.
Lordship.
Madam, not by way of this paper. You see, when he's alleging that he's 28 lakhs, court had asked you to verify. And whether you, upon verifying, you found out 99 lakhs is the thing which has to be mentioned in the way of affidavit, not by this letter.
Yes.
Yes, I.
Lordship.
And first get that 9 lakhs,
Lordship.
get the strength
Lordship.
to fight against this, both of them.
Lordship, if any date fixed, Lordship.
As
1st of December, Lordship.
61.
Hello.
But the bidding's completed
Eh?
and I'm paying for a year contractor's bill that has not been paid.
And the
And
matter come up, the affidavit in reply of the petitioner has been received as like B. So we have it for admission?
Yes.
Lordship,
What is the matter about?
matter Lordship, I have allotted some works in 2007-8. I have completed the work in 2011. Thereafter, Lordship, bill has been not paid. I have approached this court directed to pay the bill. Thereafter, I filed contempt petition. Contempt petition, they have agreed to pay the bill, they have not paid. And thereafter, they have said that the work has not been properly completed. Thereafter, in 2016, joint verification was made. As per contractor's work, I have to, my warranty is for only 1 year. 2016, they have made a joint verification. They said some damage are there. So they are not paying my bill.
Pleadings are complete, nah?
Complete,
The
Lordship.
pleadings are complete. Considering the above, this matter on. No, pleadings are complete. Mr. S. Goswami, the learned, says Goswami, the learned counsel appearing on behalf of the. S.K. Goswami, the learned counsel appearing on behalf of the petitioner submits. That this is the second round of litigation. And as such, the matter be disposed of on an early date. Taking into account the above, this matter on 20/11/2025 for disposal.
Like this.
Nishtha.